You'll give us a thumbs up here, Alan.
Yes, I will.
Senator Khan, are you
All right.
going to notify people before the amendment that they'll be limited for their testimony for the amendment to 1558, or do you want Griffin to do that?
No, I'm glad to
Okay.
do that.
All right, we are live on YouTube. I'm letting the public in. It is recording, and Griffin, I am making you the host. You are good to go, Senator.
Thank you, Alan. Welcome to this meeting of the Senate Education and Workforce Development Committee. I am Senator Jay Kahn, Chairman of the Senate Education Workforce Development Committee. Today, we will be having public hearings on bills and amendments and possibly having an executive session following the receipt of testimony. Before we get started, I'll read through a checklist to ensure that the meeting that we are holding is in compliance with the right to know law. As chairman of the Senate Education and Workforce Development Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic and in accordance with the governor's emergency order number 12, pursuant to Executive Order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I'm confirming that we are providing public access to the meeting by telephone and with additional access possible by video and other electronic means. We are utilizing software here for this electronic meeting. I believe we're calling this the Zoom platform. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to contemporaneously watch or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. Excuse me. We have provided public notice of the necessary public notice of the necessary information for accessing the meeting in the Senate calendar. We are providing a mechanism for the public to alert the Senate administrator during the meeting if there are problems with access. If anyone has a problem, please email one word, remotesenate@ledge.state.nh.us or call 603-271-3043. In the event the public is unable to access the meeting, we will adjourn and reschedule. Please note that all votes taken during this meeting shall be done by roll call vote. Finally, let's start the meeting by taking a roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during this meeting, which is required under the right to know law. Senator Deitch.
Okay. Present, I am in Peterborough, New Hampshire. No one else is in the room.
Senator Ward.
I'm here in my office and nobody else is in the room.
Senator Morgan.
I'm in my home in Brentwood, and my wife is currently in the home with me.
Senator Starr.
Hi, I'm at home in Franconia Knox. Weather's good, and well, the cat's around the house somewhere. Other than that, it's me, just me.
And I'm Senator Jay Kahn. I'm present in my home in Keene. My wife is present somewhere in the house, but not present with me in this room. Okay. I'd like to begin the meeting by asking that we all rise for a Pledge of Allegiance. If you don't have a flag nearby, Alan, we have something for us to focus on. Thank you, Senator Ward. I have a bookcase that has one, but it's anyway. Thank you. That's much more convenient. Please rise. After the pledge, we will just take a moment for silence and think about those who are suffering during the pandemic or as a result of racial tensions in our country. And Senator Deitch, would you please lead us in a pledge?
I pledge allegiance
Allegiance
To
to
the
the
flag
flag
of the
of the
United
United
States
States
of
of
America
America,
and to
and
the
to the
republic
republic
for which it
for which it
stands,
stands,
one
one
nation,
nation,
under
under
God,
God, indivisible, with liberty
and
and
justice.
justice for all.
Thank you, committee members. At this point, we are going to open the hearing on House Bill 1558. If you're following along, I'd like to, at this point, recognize the prime sponsor of House Bill 1558, Representative Murphy. 1558 is relative to the provision of special education services for older students.
Representative Nancy, Representative Murphy, you're all set.
Oh, great. Thank you. Thank you, Mr. Chair and honorable committee members. I will, in the interest of time, sort of give you the Reader's Digest version, and it's fairly simple. I brought HB 1558 forward relative to the provision of special education students for for services for older students, the request of a constituent. The goal is to put New Hampshire statute in line with federal law. And I think HB 1558 is a simple way of doing that. It would just allow students who have reached the age of 21 but not 22 to complete their school year as federal law would support. I had spoken with Department of Education. Excuse me, I'm just trying to find my little note. Diana Fenton regarding her recommendations and input, and though the Department of Education was not taking a position, she explained, number one, how that law might have, New Hampshire statute might have come to be in the first place, and how changing it as HB 1558 would benefit New Hampshire. Given also that there was a First Circuit Court of Appeals case brought in Rhode Island, which verified that which now requires that Rhode Island also comply with federal law and allow students to remain in school until their 22nd birthday. I'm hopeful that if this bill passes, that we won't be put in the position of having the state sued by a parent for failure to do that. So I know Representative Sue Mullen will be speaking for the Education Committee, and I think I'll defer the rest to her. Thank you.
Questions for Representative Murphy? Committee? If Representative Murphy is still available, I'd like to ask a couple of questions.
Certainly.
Thank you, Representative. Thanks for your testimony. The fiscal note indicates that this has little or no fiscal impact on the state, but could have an impact on local school districts. And I'm wondering how you've attempted to discover the extent of impact that this might have on local school districts.
Thank you for your question. I know at the House hearing, though that issue was addressed, and I would actually defer to Representative Mullen, because she would have the notes from those that testified to those specifics. We did have testimony from the education law and policy specialist from New Hampshire PIC. And I know somebody from the Department of Education spoke as well. I think there were more specifics as to how many students that would impact, and it's really not a lot statewide, because many students graduate before the age of 21, even though they're eligible for services. They opt to leave early or graduate prior to that time. So I know it's a small number of students across the state, but I don't have the specifics here. I think maybe the committee would have that.
If I can continue to ask, currently the statute reads between the ages of 3 or older, but less than 21 years of age. It seems pretty clear that less than 21 years of age is our current statute. This is trying to add one more year of eligibility. Is that the correct way to interpret this?
Yes, the current federal law states that, according to FAPE, a free, appropriate public education must be available to all children residing in the state between the ages of 3 and 21 inclusive. And that's the part we're just trying to add, that the word inclusive. So students who turn 21 during their, whatever, maybe their senior year, are allowed to complete the school year. And I know my own, having as a parent of a child with disabilities who has an IEP, he will not stay till he's 21. But I know our school district has historically not had students in school at age 21. I actually found out at the public hearing that other school districts do allow it. So it's very inconsistent across the state. And this would just, according to Diana Fenton, it would also just sort of clean up and allow for consistency across the state, eliminate the any confusion about interpretation by different districts, and interpretation that is actually currently contrary to federal law.
And Representative, the current IDEA, Federal Disability Education Act, it does allow states to set a eligibility that is less than 21 years of age. Is that right?
I am not certain.
And if not, that's okay. We can ask that question of others who will be providing testimony. But I think having
that is not my, oh, thank you, Senator. I'm not, that's not my understanding, but I am certainly, there are people that are far more proficient and more expert in this area than I.
Yeah, I think it's important for us to understand if currently we're complying with the federal program with the definition that we have currently. I understand from your testimony that you'd like to make it consistent with the federal guideline. And I think that's important for us to keep in mind. Right?
Yes, thank you.
Okay, no other questions for Representative Murphy? Seeing none, thank you, Representative, for being with us today.
Thank you, Senator.
Next up, I have Representative Sue Mullen. Representative Mullen, you should be able to speak.
Thank you very much. For the record, I'm Representative Sue Mullen and I represent the town of Bedford. I just want to congratulate Representative Murphy because we were under the impression that I was actually presenting this bill today. So her deference to me comes out of a division of labor more than a lack of understanding of the material of the questions that you were asking, Senator Khan. Thank you so much for having me today. I appreciate the opportunity to appear before you. To get right to the answer to some of your questions, when this bill, when House Bill 1558 was sent to develop the financial note, the first thing that came back to us was that it was undeterminable because, of course, the number of students that are over the age of 21 and requiring special education changes from year to year. But in the snapshot of the moment of time when we were actually looking at the numbers, there were a total of 43 students in the state of New Hampshire that would have been affected by this change in law. Senator Khan, you are right that IDA does allow for states to tweak the federal definition of a child with a disability. I think the salient point that Representative Murphy was addressing was the fact that when that was challenged in First Circuit Court by a parent in Rhode Island, the court, which is the very same court that we actually belong to, found in favor of the parent and said that it was not in any student's best interest for there to be multiple definitions of student with a disability. So we come to you today looking for some consistency for school districts and certainly consistency in the delivery of services in New Hampshire. When Representative Murphy's constituent contacted her, she reached out to me to ask me what the sort of protocol was in my district. And I told her that after speaking to the superintendent and the director of special ed, that it was determined on a case-by-case basis by the IEP team, and that as a rule of thumb, students who were in the school year in which they turned 21, if it was in that student's best interest, that students were allowed to finish out the school year. And Representative Murphy, we were representative of the state of New Hampshire because Representative Murphy was shocked and said, that's not how it's done in my district at all. So when the Division of Learner Support testified in front of House Education, Bridget Perry confirmed for us that they regularly receive calls from school districts wondering which of the two definitions is accurate. They regularly receive calls from parents thinking that schools are either in the right or the wrong when they're actually the other. And so our attempt here is to, as you mentioned, Senator Khan, align the state of New Hampshire with the federal definition. And we are hoping that, having heard testimony from us and perhaps people behind us, that the Senate will look favorably upon this bill.
Thank you, Representative Mullen. Questions of the committee? On the committee. And do we have any, I'd just like to ask you if you can help us on this fiscal impact. It seems that since the Senate vote, which by the way on this came out of committee 19-0.
Yeah, it was a unanimous decision of the committee and it passed on a voice vote in the full House.
Yeah, and having been there yesterday, I can see the difficulty of getting a unanimous vote from that committee. But that's impressive. But have you since then? I mean, because we've gotten some information from folks about concerns about the costs that may not be recognized with this, but
Surely.
I'm wondering if that was anything that you can inform us of.
Well, you know, as I mentioned, it's a bit of a moving target because even the year that the student turns 21 in, some students might be turning 21 in September. Other students might not be turning 21 until May. So if you're talking about extending services, it's going to differ individual to individual. And as Representative Murphy and I have already mentioned, there are some school districts that are already doing exactly what we would hope that they would, and that is allow the students to continue beyond their 21st birthday. And I'm not talking about the age of 21, I'm talking about the actual day on which they turn 21. We do have school districts in the state that are already doing that. So they're employing people through the end of the school year so that there is consistency and not an unnatural transition for, we're talking about, students that are pretty profoundly disabled because as Representative Murphy mentioned, most of our disabled kids graduate from high school. So this would not apply to them. We're talking about kids that are becoming adults, and it's a moving target. And we suspect that if you just look at the raw data and numbers, the cost would actually be less than what you're looking at because of the fact that school districts are already doing this.
The original bill had an act date 60 days after the start of the school year. Do you suppose there's any significant harm if there's sufficient time for school districts to study this bill, its fiscal impacts, and an effective date to take place July 1st of 21?
Well, I certainly, I mean, there are so many complicating layers at this point, least of which is what is school going to look like when we arrive in the fall? And will there in fact be a place for students to go? But if it's the Senate's will to push back the effective date as a means of getting this through school systems with adequate time to prepare, then certainly that is the prerogative of the Senate, and we would not argue against that. I will tell you that I do believe that most school districts who pay attention to legislative action know that this is in the works already, and that whether or not the effective date was going to be 60 days from now or 60 days from May 28th, I don't think that there is going to be that much of an impact. I think it's going to just be up to your professional judgment.
Thank you. If no more questions for Representative Mullen, then thank you, Representative, for taking time out of your day today. I appreciate your testimony.
Thank you very much.
Next up, I had, I'm going to butcher this, Rebecca Fredette. I hope I'm saying that correctly. Give me 1 second here.
Thank you. And I guess I should at this point, I know that there are a number of speakers for this bill. Griffin, I'm going to ask that if you could be the timekeeper for us, if those providing testimony can do so in 3 minutes, that will be appreciated. Thank you.
If it's all right, Jenny or Deb, could I defer? Jenny's got it. All right. Jenny will be the timekeeper.
Thank you, team. And Ms. Fredette, please identify yourself. We'll give you those extra seconds.
Hi, this is Rebecca Fredette. I'm the State Director of Special Education, and I am here with Diana Fenton, the attorney here at the Department of Education. Go ahead. I was asked to be here to answer any questions that you might have of the DOE. I know typically Bridget Pear has spoken regarding this bill, but she was unable to attend today. So I have made myself available if there are questions that you might have.
Okay. So question, thank you for representing the Department of Education. I understand that there's not a position being taken probably, but having you available for Q&A here is helpful. So committee members, questions for Ms. Fredette? I guess I can open with one. The Rhode Island lawsuit was referenced. Have have there been lawsuits that you are able to answer the question of, has New Hampshire, by deviating from the federal guideline, have we been subject to lawsuits in the past?
Good afternoon, Diana Fenton for the department. I'm not aware of any here in New Hampshire, but that would probably more be along the lines of the local district being sued. So I don't know if the department would necessarily be privy to that information.
And how long has the statute been in place that says 3 and not more than 21?
I'd have to check the law book and get back to you on that.
That's okay.
You can take a look.
Thought we might know that answer quickly. It's okay. We can. It is there. I'm sure it's been there for a while. And are you aware of the inconsistency with which that's applied through school districts in the state? Can you confirm that for us?
So it is an individual decision that is made by IEP teams based on the student's needs. I would say that on the fiscal note, we did explain that there were only 43 students that had their IEP extend beyond the 21st birthday. So while there are many students that have their IEP go until their 21st birthday, only 43 students, the team determined that it should go beyond the 21st birthday. It varies from district to district, and one of the reasons we had said the cost would be indeterminable is because we don't know. One year you could have several students that need to have that access to services beyond their 21st birthday, and another year you may only have a few that need to do that. So we wouldn't be able to determine that based on just because it's all individualized.
Thank you. I think there may be others providing testimony on that point. Any other questions for Department of Education staff? Seeing none.
Senator Khan, just very quickly, again, Diana Fenton, just to identify myself, and looking quickly in the history of RSA 186C2, I see that paragraph 1 was amended in 2003 to add in the language of aged 18 through 21. Just to answer your previous question, it looks like, and again, this is a very cursory review, but just looking at the quick history of the amendments, it looks like that was done in 2003.
You just read that you said through 21. I don't think that's the way it reads right now, right? I mean, I just want to make sure that your words were
Less than 21 years of age.
were accurately stated there.
Less than 21 years of age.
And that's existed since 2003.
Just again, a very cursory look at the history of the statute.
And the IDEA guidance that says through 21, which we don't have in law. So that inconsistency has lasted for how long? Any idea?
Well, the rules were just updated back in 2015, 2016.
The IDEA rules.
No, the New Hampshire version based on IDEA. That's the last time we did our rule change. I'm not sure about IDEA.
I'm not positive of the date, but it has been a while since IDA has been reauthorized.
So what I was asking is how long the difference between New Hampshire law and IDEA law has existed. But
yeah, unfortunately, I don't think we have a direct answer for you, Senator Khan. I think it would have to take a little bit more research, but we can certainly get the committee that information.
I think we're going to end up needing to act on the bill today. So Thanks for attempting to provide all the details that may or may not have any influence on us and our votes today. So thanks for being present with us. And please, if you feel during the hearing there's a need to raise a hand, do try to communicate with our Senate staff.
Thank you, Senator. Thank you.
Our next speaker is Ken Norton.
Welcome, Mr. Norton.
Thank you, Senators. And my name is Ken Norton, and I am the Executive Director of NAMI New Hampshire. I'm also a former foster parent and an adoptive parent through DCYF, and have had experience firsthand with the special ed system and its successes and failures. And I just simply want to say that, I mean, NAMI New Hampshire supports this bill, that statistics indicate that 1 in 6 students age 6 to 17 experience a mental health diagnosis, and that 50% of all lifetime mental illness occurs by the age of 14, 75% by the age of 24. And many of those students do not get the special ed and educational services that they need. There's certainly a lot of information about the pipeline between special ed, those that do go to special ed, and jails. I've experienced that personally as well. And we really feel that extending the age to 21 will help reduce the gap for some of these students with disabilities and make them increase the likelihood that they can be productive and functioning members of our communities. I'd be happy to take any questions.
Mr. Norton, just for clarity, you just said extend the age to 21. Would you just clarify that?
Yes, so that as written, that it would be inclusive of age 21.
And through age 21.
Correct.
Is what you are supporting. Thank you. Well, you certainly have great insights into mental health issues facing our state. Thank you for your testimony. Is any questions from the committee members? Seeing none, Mr. Norton, thank you for being present in your testimony.
Thanks.
Our next speaker is Robert Beville. I hope I'm saying that one correctly. Robert, you should be able to speak.
Good afternoon, Senators. Thank you very much for hearing from me. I'm Bob Beville. I live in Merrimack, and I live 3 houses from Representative Nancy Murphy. And I appreciate that she sponsored this bill for me. Under the federal guidelines of 34 USC 300-101, it specifically says that the children are available for these services between the ages of 3 and 21 inclusive. The purpose of this bill is to maintain a stability across all the school districts on this. I had the honor of serving one very hot summer with Senator Nancy Stiles when she was on the House side, where that we were working with House Bill 661. At the time, it was to include the revised changes of IDEA 2004 into the RSA 186C. This is when the change occurred that you were asking for, Senator Khan, as to the inconsistency. And again, the committee did a yeoman's job of trying to include all those things and get it all done. But as my own children are experiencing this, there is an inconsistency across school districts as to whether they have 19, 20, or 21. And again, it was correct from Representative Mullins. It is the IEP team who decides what's appropriate for the child. But unfortunately, in some school districts, the parents are being pre-coached that that time is going to be something less than what the federal standards are. And so what I'm trying to do is with this law to establish what the floor is, not a ceiling. And the floor by the federal standards is age 3 to 21 inclusive. Thank you for your time.
Thank you, Mr. Bevel. Is it your experience that children needing services through 21 have been denied services?
I would not say that they were denied services. They were not told that they were available. And that to me is what needs to be. If you don't know that you have the right, sometimes you lose that right. And this is not for those children who need an extra year or two to receive a diploma. These are children who are getting a certificate of completion. Once they leave the school district, many of these are severely disabled children. Once they are gone and no longer under the umbrella of IDEA Act, they have no protections as to any services, any whatsoever, from the state or federal government after they turn 22. And so sometimes it's very important in those last few months, 6 months to 18 months, that these children get proper transitory services. So when the school district is handing them off to the state services, that they maintain that level of services and those are provided for them. That's what I'm making sure these children don't fall through the cracks.
Thank you. Any questions from the committee members? Thank you, Mr. Bevel.
Thank you very much.
Thanks for attending.
Our last speaker is Gerald Zellen. If there's anybody else who wishes to speak on this bill, I ask that they please raise their hand. Give me 1 second, I just got to find him. Gerald, you should be allowed to speak.
Can you hear me now?
Yes.
Yes, okay, thank you. My name is Gerald Zellen. I'm a lawyer at the law firm of Drummond Woodson in Portsmouth, New Hampshire. I'm speaking on a volunteer basis, not as a paid lobbyist. I'm speaking on behalf of the New Hampshire Association of Special Education Administrators, which consists of virtually every special education director in the state of New Hampshire. And if I had more than 3 minutes, I would give you an earful about how so much that you've heard thus far today is so incorrect. But I have given you a letter and I've given you an email. And I just want to highlight a few issues and then I'll be available for questions you may ask me. First of all, having heard what people are saying today, I'm struck by what is the problem we're trying to solve? Because as articulated, the problem being solved is that some students reach their 21st birthday in the middle of the school year, and there is inconsistency among school districts in whether they'll be allowed to complete the school year. But this bill does not do just that. This bill allows the child to continue to receive special education up until the 22nd birthday, even if the child turns 21 at the end of a school year before the next school year begins. So if the problem is allowing a child to finish the school year, then craft a bill that allows that. This bill has a much greater magnitude than that. Second, I want to address the issue of the financial impact. And I think as a practical matter, as a lawyer who represents many, many school districts in special ed, and I've done this since the IDEA became effective in 1975, which was the year I got out of law school. There are basically two categories of children who will be impacted by this bill, and they're two very different categories. Category one, children with autism or extreme levels of intellectual disability who are attending their public high schools and then spending much of the day in transition, what are called transition services, school to work programs in the community, et cetera. And asking a school district to continue to provide special ed for that child until the school year is over, even if the child reaches age 21 in the middle of the school year, will not have a huge financial impact on school districts. But there's another category of children, those with severe autism or intellectual disabilities who are being placed by school districts in residential schools that can cost $200,000 a year or more. And under our system, under RSA 171A, under the status quo, the area agencies will pick up those children when they reach age 21 and place them in community-based group homes.
Mr. Zelen, I'm so
Yes.
sorry to interrupt, but your time has expired.
Oh. Well, time flies when you're having fun. I'm available to answer questions if I might elaborate.
Yeah, Mr. Zelen, I guess I'd ask, thank you, Jenny, for trying to keep us to some standard. Would you please complete the thought that you were just?
Thank you. Well, I just want to answer a few of you. The rest of my remarks are to answer questions that you folks have raised. First of all, when was the age limit of the 21st birthday inserted? It was inserted when in New Hampshire's original special education law, RSA 186A, which reflected our regular education law, which offers regular ed to the 21st birthday. In 1981, the state of New Hampshire replaced RSA 186A with 186C, and 186C is enacted back in 1981, retained that age limit of the 21st birthday. So we've had this age limit back since 1975, since New Hampshire first elected to participate under the IDEA. Secondly, there are no lawsuits that I'm aware of, having represented many school districts, no lawsuits against school districts trying to assert a right to special ed after the 21st birthday. And lastly, I note that the KL decision involved the idiosyncrasies of Rhode Island's adult education system. And the court there did not say that it was bad to offer special ed only until age 21. The court instead, by a 2-to-1 vote, interpreted the interplay between the IDEA and Rhode Island's own adult education system as creating a right to special ed to the 22nd birthday. There have been no lawsuits in New Hampshire against districts or the state raising a similar ground. And if there were such a lawsuit, then a school district would be able to defend itself instead of losing that lawsuit in the legislature today. But finally, the IDEA and the KL decision don't require any school district to pay for special ed beyond the student's 21st birthday. They both impose ultimate responsibility on the state. And the KL decision ordered the state to pay, not any school district to pay. And as what I submitted to the committee indicates, Part 1, Article 28A of the New Hampshire Constitution similarly says that if you enact this law, it will be the state that should pay, not school districts. Thank you.
Thank you, Mr. Zelen. Questions for Mr. Zelen from committee members? Mr. Zelen, you said the KL decision. What did that? What's KL?
Oh, that's the First Circuit decision that was alerted to earlier. KL versus Rhode Island State Board of Education, where the First Circuit, by a 2-to-1 decision about 2 years ago, said that because of the interplay between the
I got the decision. I just wanted to make sure we understood the abbreviation.
I apologize.
But that's obviously a plaintiff. Yeah. Okay. Any further questions for Mr. Zelen? Mr. Zelen, your primary concern there is that there are services being provided through community area agencies at age 21, and that we might be creating something that overlaps with that service?
It's one of my concerns. This bill could be vastly improved and would be an excellent bill if it were amended to provide that the state pays for that extra year of services. And if RSA 171 were amended to make it clear that the expansion of the population served by special ed does not contract the population served by RSA 71A. In other words, to amend RSA 171A to say that this bill does not reduce the responsibility of area agencies to provide services to students 18 or above.
So how do they negotiate that now? I mean, if we've got an age limit to 21 and they're allowed to provide services at 18, we have that overlap today.
Well, we have an overlap today, but in theory, the way it works is many area agencies, as soon as they hear the child's in special ed, regardless of age, run away from the child. Other area agencies say, well, if you're receiving special education, we'll provide you with services, but a lower level of services until you exit special education. So they do not provide the community-based group homes, the least restrictive environments, until the student exits special education. So by increasing the ages covered by special education, those area agencies will then be decreasing the populations they serve, which will lead to the disadvantage of their clients.
Thank you. Any other questions for Mr. Zelen? Thank you for your letter, attorney, and appreciate that you were present for our testimony today. Appreciate it.
Thank you.
Thank you.
Senator Khan, I don't have any other speakers. However, Mr. Bevel has his hand raised, and I'm assuming he has some comments he'd like to share.
Okay, before we close the hearing on the main bill, Bevel, briefly.
Yes, sir. Thank you. Can you hear me okay? The
Got it.
only thing I'm asking for in this bill is just to match up what already exists in 34 CFR 300-101 so that the languages match, which says between the ages of 3 and 21 inclusive. That's all we're asking for, is so that they match. And if there will be other decisions based on area agency, I could go down that road telling you those services aren't always available and there's not always budget. But I'm just saying the purpose of this bill is to make sure that the state matches the federal, which is supposed to match up with all of IDEA. Thank you very much.
Thank you. Well, Griffin, seeing no more testimony?
Seeing no more testimony, I think you're safe to close the hearing.
In which case we will. We will close the hearing on Senate on House Bill 1558 and thank all who made the time to testify. We're now going to open the hearing on amendment to 1558, amendment number 1384S. And I'd like to take a moment just to lead us through on this bill, which begins on page 234 of the Senate calendar. As you can see there, the first section of the bill is specific to the provisions in 1558, which we just discussed. Added to the bill then, through this amendment, are a number of bills that have been heard previously in the Senate that had significant majorities for them, or they are House bills that passed handily and that we have seen previously in the Senate Education and Workforce Development Committee, either in this session or in a previous session, and we're aware of the work that needed to be done on these, which I think has been significantly completed in the House. So section 2 of the bill begins to describe the probation and suspension statutes of the state and how to address the behavioral needs of students. But it really is specific to suspension and expulsion in section 2 and continues through that section. I'll note that deleted from this bill are sections 3 and 4 of the bill, I'm sorry, sections 3 and 4. And the reason for that is that we have Senate Bill 665 here that defines a children's system of care in sections 27 through 31. So we have had a redundancy between House Bill 677. Section 3 of 677 had an appropriation language for a children's system of care, and that was essentially stripped out by the House Finance Committee. So I think we've got in this amendment the guts of HB 677 up until the point that it began to introduce language about a system of care, and then that system of care is picked up elsewhere in the bill. This, by the way, 677 cleared the House on March 5th with a vote of 259 to 90. So clearly had bipartisan support for it. Senate Bill 625 relative to kindergarten. I believe this bill had some basis in the House as well. This had bipartisan support in the Senate and is represented in section 3 in the bill. Section 4 through 11, these sections come from the bill relative to economic revitalization zones and tax credits, therefore, and the New Hampshire College Graduate Retention Incentive Partnership. This bill 661 cleared the Senate and was taken up by the Commerce Committee previously. This passed without exception in the Senate. What this does is that the rather than relying on a contract for entering into these enterprise zone tax credit program or the college graduate retention incentive programs, that the BEA commissioner be authorized to verify that and certify that those applicants have met the guidelines established through existing statute. Senate Bill 556 is relative to violence in schools. It was taken up by the Commerce Committee and amends parts of our labor statutes. This is contained in sections 12 through 16 in the bill. I just want to make sure that I'm catching up and tracking with my notes. Beginning on section 17 is a bill considered by the Senate through this committee on head injuries and policies for schools related to that. That's section 17. And just below that, on page 240, is section 18 and 19 on the next page, which are relative to child sexual abuse prevention, education, and training by school districts. Section 20 of the bill amends the Municipal Finance Act and is relative to the issuance of bonds by municipalities through town meetings. This is specific in section 20 through 23, allowing for a 60% vote to be uniform between town meetings and town ballot means of approving warrant articles. Senate Bill 565, allowing the university system to add its chancellor to be a part of a partner council agency, a partner council to advise the Commissioner of Business and Economic Affairs. That bill has been incorporated into section 24 in the bill and is a very brief change. House Bill 1328 is one that appeared with the Senate last year. It was re-referred by the House actually it was re-referred, I think, by us. Maybe we defeated it, but the point is that the authors of the bill continued to work with partners in the education community to develop a compromise that is part of 1328 and is reflected in section 25 in the bill. This section allows parents to make an appeal to school districts for assignment of their student to another school and requires the school to hold a hearing and have policies for those hearings to consider such a request. Senate Bill 675, relative to year-end expenditures, allows school districts to have a slightly larger, up to 5% of their annual appropriation, not their appropriation, but what's called a net assessment in the statutes, allows them to retain up to 5% and to use those for emergencies dependent on the following rules or this statute, which would require them to have public notice of a hearing to spend those dollars and include a report on their expenditure of those dollars in their annual report to their taxpayers. That's section 26. In section 27 through 31, we consider the children's system of care and student wellness. So this relates back to the House 677 bill. And in sections 32 through 34, Senate Bill 760, considered in the Commerce Committee, relative to criminal background checks for school bus drivers and the role of the State Board of Education in holding and setting guidelines for those background checks. That is incorporated into the bill. What is going to be offered by me later after we close the hearing on Amendment 1384 will be another amendment, which is numbered 1398, because what you'll notice in this bill at its conclusion, there are sections 35, I lost my place. There are sections 36 and 36 and 37. I would call your attention to particularly because these are redundant to sections 18 and 19 in the bill. So rather than leave this redundancy in the bill, I'll offer it in a subsequent moment that we delete sections 36 and 37 because they're not needed. Then I'd call your attention to section 38, which I think is most important. This is where the effective dates of various sections exist. And they vary for the section, so it's worth noting those effective dates as you go through the bill. If there are any questions from senators, I'm glad to address those. Otherwise, look forward to testimony on the amendment as printed in the calendar. Seeing no questions from our colleagues, Griffin, would you call of those who have, how many people have we got testifying?
I have 14 total at this time. And Senator Waters is going to be the first, and he's already raising his hand, so I'm going to bring him in.
Thank you, Senator Waters.
Oh, I apologize. Senator Waters, before you start, I saw that Senator Starr had his hand raised. I'm just going to, do you mind if I call on Senator Starr first, or do you like to finish with Senator Waters?
No, it's if he's, no, if we missed him first.
Yep. Senator Starr, go ahead.
Yeah, they're certainly packing a lot of stuff into this amendment. There's the section that gives special treatment to the Brain Injury and Brain Injury Association. I really don't agree with that. Kids can get injured a variety of ways in school. Broken limbs come immediately to mind. I don't see why we should give brain injuries special treatment at all. And this Brain Injury Association gets a special position to give advice.
Yes.
And then, then there's the fallout money bill. This is the one where we allow the school board to retain any money left over after, I guess, the end of the year. We used to have this in the service. At the end of the fiscal year, all sorts of money which various higher headquarters had been holding on to in case of dire need. The Constitution requires that the Army and the Air Force appropriations all be spent the year they're in. The Navy gets 2 years. And what we did in the service was when the fiscal year ended and there was a little money left until, we dashed right out and spent it. There's always something you can spend it on. We found them. I can remember a conversation between our director of materiel and the base supply officer. And the DM says something like, Fleming, you know the fallout money will be coming down shortly. Will you be able to get it all spent in time? And Fleming said, yes, sir, Colonel. I just turn on the computer and the lights start blinking and it spends money at $1,000 a blink. And essentially, if I'm a school board, under current law, if I'm required to return any leftover money, hell, I'll spend it. There's always something. If we let them keep it, they'll spend it on something that they really need, or they'll put it into a rainy day fund, which is probably a better use of taxpayer money.
Thank you, Senator. I think we're beginning to argue the bill as opposed to accept the testimony. If you don't mind, I think we could call Senator Waters to address your question about the brain injury concern there.
Sure.
I think that's part of his likely testimony. He's the prime sponsor on that bill.
Well, thank you, Mr. Chairman, members of the committee, and also thanks to the staff for putting together this hearing and this omnibus bill under these unusual circumstances. But I really appreciate the good work of the committee. I will speak first to Senate Bill 584. In fact, as you all will recall, we had a very thorough conversation of this bipartisan bill in the original committee hearing in the Senate, and it was demonstrated that this procedure actually would simplify the work of the Department of Education by going to the best available science that is available about brain injury, and that this group would be able to efficiently provide the kind of information that the DOE could have to pass on to school boards. And we certainly have been a pioneer in this state on return to play when it came to head injury. And I would hope that we could also understand that these students not only get back on the field, but they get back in the classroom. I did want to say, Mr. Chairman, members of the committee, and the reason I came to testify today on this on 7/11 is that our circumstances under COVID-19 with remote learning, I think, give this bill and a special need for us to pass at this time. Clearly, if we are in remote learning or in a hybrid learning situation, there will need to be extra efforts to be sure that students who have had a head injury will be able to be educated and get the help they need in this new learning environment. So thank you, Mr. Chairman. And I will say just a few words on 7/11. Again, I want to thank the committee so much for its work on this bipartisan bill, and it builds on many of the efforts we have done on child sex abuse education. I think here the words I wanted to add, because we did had a very thorough hearing and a positive vote previously, is that what we are hearing from the advocates is that they anticipate that there will be much more that is going to have to be dealt with students who may be disclosing sexual abuse when school resumes. There is certainly information by the volume of calls coming into the centers about concerns that having the students at home sometimes can create this situation. But it also is important because certainly with the kind of social distancing and the new kinds of situations that students will find themselves in when school does return, means that there will be more personnel who ought to receive this appropriate training and to make sure that our students are going to be safe and protected as they must be under statute when schools resume in the fall. So thank you very much, Mr. Chairman, and I will, of course, be glad to take any questions.
Questions for Senator Waters? Senator Waters, seeing none, I just want to thank you for bringing forward your bills, for continuing to advocate for them during this process, and thanks for your service.
Thank you, Mr. Chairman.
Next, I have Representative Kermit Williams signed up to speak, but I do not see him listed. If the representative is here, I just ask that he raise his hand. Otherwise, we will move on to Rebecca Fredette from the Department of Education.
Welcome, Ms. Fredette, again. Thank you.
Good afternoon. Diana Fenton, as I said, is here with me and she's going to speak.
Good afternoon. For the record, Diana Fenton. I'm an attorney with the Department of Education. We wanted to raise a concern with one of the amendments. I want to direct your attention to the bill addressing the system of care for children's mental health, which would amend RSA 135 F5. We do have some concerns, and Rebecca is here with me, about the use of the federal funds for IDEA and whether or not that would be allowed. That the designation of IDEA funds, as set out in this bill, we believe would not be permissible. And we do have some concerns with that. And it's something that Rebecca has identified as well. And you'll find that in paragraph 2, paragraph 2C, the federal funding participation. The state set aside funds received from the federal government under IDEA. And we have some concerns about whether or not the state can actually do that.
Okay. That the complete your testimony?
Yes.
If you'd be available for questions, I know I'll have one here. Anybody else?
Senator Khan, this is Senator Morgan.
Thank you.
Thank you for your testimony. Just could you explain a little bit further to us about where the specifics around your concerns on the use of the federal funds?
So within the, are you on? No. So within IDEA is 34 CFR 300-704 B4 sorry. So it does reference that we can support positive behavior interventions and supports to mental health services for children with disabilities. However, it says that we would be assisting LEAs. It does not state that we can be assisting another agency within the department. So there is a concern that this would not be an allowable activity for us to support through IDEA funds.
Thank you. Senator Khan, this is Senator Morgan. I'd
Yes.
be curious to know if there's any way for us to get Senate counsel or other, just a additional legal insight into this testimony.
Right. And so let's continue to try to clarify this. I believe that these funds that are identified in 2C currently are sources of funds for an MTSSB programs at local education agencies, right?
Yes, they are. However, they go to all students, and IDEA funds are specific to special education students. So,
Right. But so I guess I want to pick this apart because, sorry, but I think your objection is that the first couple words there is develop a plan. The idea of the Department of Education developing a plan with these sources of funds is problematic. Is that what I heard you say?
no, ours was with 2C, where it states federal funding participation includes but not limited to set aside funds received from the federal government under IDEA. And then it lists several other funds that would be looked at as well.
So what portion of that do you object to? I mean, which words?
So we're not sure that we can use the set aside funds from the federal IDEA monies to support this system of care.
Are we using that source of funds now?
We are supporting the Bureau of Student Wellness currently, but we are looking into whether this is how we are supposed to be spending our funds that way.
So we could have Senator Morgan puzzle over this as we're continuing through here, but within the guidance of federal statute that the department use these funds. That the kind of guardrail that we need to have?
Could you repeat that again? I'm unclear what you're asking me. I'm sorry.
If we added a couple of words to this section that not limited to, and maybe instead said the use of within the guidelines established by these programs Is that going to be a good enough substitute?
If they had it within the guidelines of these.
Well, we can use the funds for IEP students in special ed programs,
But
and
he-
that's what it needs to specify.
Right, so we could use the funds for IEP students, and it would just need to specify that the funds are targeted to IEP students. And you could add the wording in there that says, sorry, like the two of us are consulting, that's why it's taking me a minute to answer your question. So you could add in there that as allowable by the statutes under IDEA and their wording, or however you would want to change
Yep.
that wording, yes.
It sounds like, as allowable, sounds like the
Right.
the proper addition. Senator Morgan, have we had enough guidance here that you can take a look at this while we're accepting other testimony on other sections and give us some further advice later?
I will, yes, I will try to get, I'll try to get this together.
And it sounds like an as permitted.
As allowable by, yeah.
All right, any other questions? Thank you for that catch, Rebecca. Anybody else with questions? Thank you again for making yourselves available and helping us find proper wording here. Thank you.
Our next speaker is Elizabeth Bilecki.
Hear me now?
Director, could you speak up one more time?
Sure, can you hear me okay now?
Yes.
All right, thank you, perfect. Good afternoon, and thank you for the opportunity to speak. I am just chiming in with a technical correction on section 32 through 34 of the bill that has to do with the school bus drivers and criminal background checks. We don't have any issues with the intent of the provisions of those sections. However, the way it is constructed currently by removing school bus drivers from section 32, it effectively strips us, the Department of Safety, of the authority to run an FBI criminal background check and provide the results of such background check to the Department of Education. I have spoken with Senator Kavanaugh and provided him with language that would restore that authority and still continue on with the intent of this proposed legislation. I'm happy to share that with you as well, but my ask would be that we add those provisions to this particular section so that we can have that authority to be able to continue with what the intent was of these three sections.
So help us with, thank you for helping us clear this up then. If we look at section 32, I understand the suggestion that we add school bus drivers in, but then we've got the sentence down below that exempts them from this section. Can you just sort that out for us?
Sure, absolutely. The intent of this section falls in RSA 189.13a, and I know Diana Fenton is on listening as well, so perhaps she can clarify that as well. But RSA 189.13a speaks to the ability of school districts and the superintendents and their authorization to run fingerprint-based checks for various school district employees. Because the intent of this bill was to create this clearinghouse within the Department of Education to specifically deal with school bus drivers and transportation monitors, school bus drivers were removed and exempted from this particular section. What we are proposing in our draft is adding an additional section to 189.13b to specifically authorize the Department of Safety to run this kind of background check and then share it with the Department of Education, specifically for school bus drivers and transportation monitors. So while this was a carve out from 189.13A, we need to put that somewhere to continue with that authority to have that process in place.
Okay. So are we good with the wording in both places?
I have a proposed revised language. I'm happy to share it with Griffin if you would like to see it and have the committee take a look at it quickly. We've got some revisions to this paragraph and some additional language that would need to be added.
I would like you to read what it is. We should have gotten this in advance, I think.
I apologize. I know
I
you were
failed
working
to.
on that today. It's rather lengthy. I can read it to you if you'd like. I'm going to try to pull it up very quickly.
Griffin, do you have the ability to share this wording back with us?
Yeah, if Director Bilecki, if you want to email me the proposed language, I will forward it to the committee aide as well as the other members of the committee here, if that makes it a little easier.
Absolutely. I'm working on it right now.
All right.
All right, that's probably the most efficient way to do this. Anything else, Assistant Commissioner?
That's really it for us. We're just trying to ensure that we can continue on with this process and have this authority in place, because without that, the FBI will not allow us to continue with the background checks specifically for school bus drivers and the monitors.
Okay, I'm certain that that wasn't the intent. Thank you for your testimony. No other questions? Thank you. And please get that information to staff. You know how to be in touch with our clerk today?
I have just sent that over to Griffin, so he hopefully has it in his mailbox.
I have it. I'll forward it along in just a moment.
Thank you.
Thank you.
Let's see. Next, our next speaker is Michelle Wangren. One moment here. Yep.
Thank you, Honorable Chair and members of the committee. My name is Michelle Wangren. I am the Director of the Youth Law Project at New Hampshire Legal Assistance. NHLA provides civil legal representation to low-income individuals and seniors, including educational representation and advocacy to youth with unmet educational and behavioral health needs. While NHLA supports the omnibus bill as a whole, I'm focusing my testimony on part 2, which modifies the standards for suspension and expulsion of pupils. If this language seems familiar to you, that's because it is. The language in this section of the amendment was formally incorporated within SB 302 and HB 677, both of which passed through their respective bodies with broad bipartisan support. The language presented to you today was developed with the input of a broad group of stakeholders and was fine-tuned through the course of multiple House work sessions. You will hear more from other speakers about the interplay of the school discipline bill with sections 27 through 31 of the amendment, but I strongly urge the committee to support both of these bills and continue exploring fiscal resources to support the behavioral health needs of New Hampshire students into the future. Because I previously testified much more extensively on SB 302 before this committee, I will keep my comments to a brief recap of the shortcomings of this current school discipline law and the most important features of this bill. I'll remind the committee that under current law, New Hampshire schools have broad discretion to suspend or expel students for any offense and for any length of time. Recent data from the Office of Civil Rights illuminates stark disparities in the administration of exclusionary discipline to students of colors and students with disabilities, with the combination of those demographics being 5.5 times more likely to receive out-of-school suspension than their white non-disabled peers. This bill emphasizes exclusionary discipline as a tool of last resort, while maintaining school administration's ability to exclude students who pose health or safety risks to other students or school staff. It requires schools to develop policies on school discipline that are likely to lead to the fair and dispassionate administration of discipline. It ensures that students who receive long-term or repeated school exclusions have the opportunity to keep up with their coursework so they can return to school ready to learn. It emphasizes creation of interventions to address problem behavior rather than allowing the behavior to continue upon a student's return to school and resorting to repeated or long-term suspensions. And finally, it cleans up long overdue gaps in the current school discipline law to clarify its application to public charter schools and the process that districts should follow when expelled students move into a district from out of state or from another district. You will hear from other members of the Juvenile Reform Project, a diverse group of advocates, including Waypoint, DRC, ACLU New Hampshire, and New Futures, all of whom were instrumental in the development of this bill. And to prevent duplication of testimony, I will end here, but urge the committee's support in passage of HB 1558 as amended. And I'm happy to take any questions.
Questions from committee members? I noticed the definition that's, I'm going to ask you about section 2 and subsection Roman 1AA, or Roman B, I'm sorry.
Mm-hmm.
And the language that is here bolded that makes reference to 193D and excludes certain certain acts by students that might result in more serious suspension. Where the wording there, that was derived from someplace and I'm not sure where. Could you just explain?
Sure. The 193D language came from what's currently in the New Hampshire rules for the suspension and expulsion of students with disabilities. So that language is already in New Hampshire rules as one of the reasons that it may be appropriate for schools to implement longer term suspension or expulsion. So it used to be that the New Hampshire rules allowed for some form of ladder disciplinary process where it said, you know, certain types of offenses may receive a lesser suspension, offenses that are pursuant to 193D or other gross misconduct may be appropriate for a longer term suspension or expulsion. Then in, I believe it was 2011, the New Hampshire Supreme Court said that because the statutory language is so broad, the Department of Education through its rulemaking process cannot limit what's currently in statute. So that 193D language brings back some of the latter disciplinary approach that the Department of Education had previously tried to implement that was later invalidated by the Supreme Court.
So you say New Hampshire rules, is it Ed rules?
Yeah, it's Ed 317.
And that this is a direct out of there?
The 193D language is, but the additional bolded part of the provision was developed through the House subcommittee process, where that's where we added additional acts that may be appropriate for the longer term suspension, including bullying, the possession of firearm, BB gun, or paintball gun. That was taken from Ed 317. It was the bullying language that was not taken directly from Ed 317 that many of the stakeholders believed should be put into this provision.
So to be specific here, if I look at 193D1 and the definitions there of violations of safe school zones, and I see unlawful possession or sale of a firearm, that's slightly different language from what I see here that comes from Ed rules. And I just want to make sure we're grounding ourselves with consistent language or language that otherwise could be confusing to somebody later.
Right, I think, so the 193D language was in the prior rules before those were removed after the Keelan B decision. If that, does that, I'm not sure if that makes sense. But so there are a lot of offenses within 193D, which includes illegal substance possession, which isn't necessarily apparent by looking at acts of theft, destruction, and violence. So there are a lot of categories of offenses listed in 193D that are some of the more violent and egregious offenses. But it had previously been determined by the Department of Education that possession of firearm, BB gun, or paintball gun are sort of separate offenses that should necessarily indicate a suspension or expulsion may be warranted. There's also some other law, so there are other federal laws that apply specifically to possession of a firearm, and that's a whole other body of law that I think this bill remains consistent with that.
Thank you. So to summarize, this language is consistent with New Hampshire education rules. And regardless to what we have relative to safe school zones in 193D.
That's right.
Thank you. And Ms. Fenton probably is still listening to us, so if there's anything wrong in that, I'm sure she'll point that out. Any other questions for Ms. Wangeren? I thank you for your persistence on this bill. You've worked with a lot of parties to try to help bring this forward, and I appreciate your work. Thank you.
Thank you, Senator.
Next.
Next speaker is, I believe, Michael Skibby. Give me 1 second. Michael?
Yes, can you hear me?
Yep, go ahead.
Good afternoon, members of the committee. Thank you for the opportunity to testify. My name is Michael Skibby. I'm the Policy Director of the Disability Rights Center. Testifying in support of provisions of the amendment that include the school discipline reforms that you were just discussing, and the addition of language supporting the implementation of the multi-tiered systems of support, which you were also just discussing. As you know, the discipline provisions start at section 2 and the MTSSB provisions begin at section 27. I think the way that I think about this legislative package is that there's really 3 important aspects to it. One is that it reduces the use of exclusionary discipline because it can cause harm to children, families, and ultimately public safety. But that it does that while retaining the tools that schools need to keep schools safe and orderly, even when that tool requires the use of exclusionary discipline. But it also adds supports that will help schools reduce the incidence of difficult behaviors and the behavioral health problems that cause those behaviors, or at least associated with those behaviors, so that they don't need to use any discipline, and certainly exclusionary discipline, as much as they might have to without those supports. We've spoken at length with you about these provisions. You've seen a couple different versions of them, and I won't belabor the reasons for them, but I do want to make an observation about our current circumstance. Our schools have been working extremely hard at making remote education effective, including for children with disabilities. There's been a tremendous amount of creativity and energy devoted to keeping all children engaged with their education during the pandemic, and that includes kids with IEPs and 504 plans. Unfortunately, remote education is not working for everyone, despite that tremendous energy that's going into it. And the lawyers in my office have been talking to a number of families of children with disabilities who are seeing their children fall behind. And we expect to be working with those families over the next couple of years to try to help them make up lost ground and advocate on their behalf for the specific things that they're going to need to get back fully engaged with their education. The reason that I mention this in the context of the school discipline reform is that that disengagement, that kind of disengagement weakens the connections that these children have to their school, to their teachers, and to their peers. And that's exactly the kind of thing that school discipline reform is intended to address. Exclusionary discipline weakens connections. It contributes to alienation and a sense of failure on the part of students, and increases the chance of dropout, delinquency, and adult criminal behavior. We should be doing what we can to strengthen, not weaken, connections to the schools for these children who are struggling under the current circumstances. And adoption of the reforms are therefore especially important at this time.
Mr. Skippy, I'm so sorry to interrupt, but if you could just wrap up your thought, your time has expired.
Thank you. That was what I had prepared. I could make a comment or two about the federal funding issue that came up during a question, but I will leave that to you as to whether you would like me to address that. Thank you. Should I address that?
If Senator Khan is not here, I'll step in and as vice chair and say, oh, he is here. Okay.
Please do.
I would like to hear the comment on.
All right. I think that the important thing to note is that this provision, it's on page 17 of the amendment that I have in front of me. This section Roman 2C, it regards the development of a plan and the requirement that the commissioner develop a plan. It doesn't require the spending of a single dollar, and certainly not the spending of any money in any amount in any particular category. And so I think that this section is not inconsistent with the federal funding constraints that were described to you by the departmental representatives. And I think it would be entirely appropriate for them to develop a plan that complies with the statute or with the legislation as currently phrased, that would say, we propose to not use this kind of funding because of the following federal statutory constraints, or preferably to say, we're going to use this federal funding, but in order to comply with federal constraints, we're going to direct it in the way that they were suggesting it had to be directed. That is to an LEA rather than to the department. And I think that would be fully compliant with federal law, and it would not require you to amend the bill. I'd be happy to answer any questions.
Thank you, Mr. Skibby. Any questions from the committee? Thanks for your clarification there and for your testimony.
Our next speaker will be Brian Hawkins. Brian, when you're able.
Great. Can you hear me?
Yep.
Great. Thank you, Mr. Chairman, members of the committee. For the record, Brian Hawkins with NEA New Hampshire. Also, thanks to the staff as well for putting the remote hearing together. I wanted to testify in support of the amendment and specifically highlight sections 12 through 16. As Senator Khan said, this is the product of the study committee that met last fall around violence in schools. And those sections are from Senate Bill 556, which had gone before the Senate Commerce Committee, received a 5-0 recommendation out of Commerce and a voice vote on the Senate. The main components of this were coming out of the, as I said, coming out of the study committee. And they do three things. One is that schools need to have safety plans and protocols in place that are communicated and trained on by everyone who's interacting with students. And this is done through bringing management and labor together under an already existing entity, the Joint Loss Management Committee, under the Workers' Comp statute. We believe this will help produce procedures that'll work in particular for that particular school district, because it'll be management and workers coming together to develop that plan, and bringing those different perspectives in the school allows for input from administrators, to classroom teachers, to paraprofessionals, and it improves the likelihood that these protocols are going to be better communicated to everyone who needs it. The assaults on educators that the study committee heard about, this is the new worker safety issue in our schools. If we have better plans in place, that will be good for the safety, both of our members and most importantly for the students that they care so much about. Secondly, also coming out of the committee observations was important that the legislature make crystal clear that discouragement from reporting injuries as a result of these assaults is not okay. Too many times we've heard about our members say that the new norm of educator assaults is simply that it's part of the job. And this is not what we're here to do. And the protective language added here to the existing labor statutes is one that we worked on with the conjunction with the Department of Labor to clarify that. And we hope the Commerce Committee certainly agreed. We hope you will too.
Mr. Hawkins, I'm so sorry to interrupt, but your time has expired. If you could wrap up your final thought, please.
Sure. Finally, the last provision is around reporting, and that really is to help the legislature make future decisions on resources. If you don't have the adequate reporting, it's hard for you to make decisions on resources going forward. I'll conclude my testimony and appreciate the time.
Thank you, Mr. Hawkins. Any questions from the committee? Seeing none, thank you, Mr. Hawkins, for your work on this bill.
Thank you.
I believe Senate Legal Counsel Greg Silverman has joined us to answer some questions that I believe Senator Morgan had, so I will defer to him.
Hi, everyone. I am here.
Senator Morgan.
Yes. Thank you. Just switching audio. Thanks for your patience, and thank you for being here, Attorney Silverman. The
Great to be here.
The question that we had was around the language of the amendment to House Bill 1558. If you turn to page 17.
200, right, or 246, and if you've got the Senate calendar.
Thank you.
I'm sorry, what page was that?
246, is that what you said, Mr. Chairman?
Yes, it's page 240, but it is section 30 of the bill and Roman numeral 2 and C. Is that correct, Senator Morgan?
I am working. I have two.
This is system of care for children's mental health.
Yeah. So federal funding participation is what 2C starts with.
Okay. Yep.
So there was a question by the department on whether or not it is allowable to use federal funds associated with IDEA for as is described here. And so the question that I had, and Mr. Chairman, please feel free to jump in at any point, But the question I had was whether or not at the end of that paragraph, we could simply add as allowable by IDEA and ESEA requirements, and whether or not that would suffice.
So I think that this is about developing a plan and it shall address at least the following elements. So I think that if federal funding is somehow unavailable, that could be either confirmed at a later date or, you know, sometimes federal funds may be available for certain things, but not others. And so I think, you know, subsection C just says federal funding participation.
Can I offer some words there, Greg?
Sure.
Would you consider the words federal funding, and that's where the insert I think fits best, federal funding as allowable should include but not limited to? I mean, if we put the as allowable right after federal funding, will that help us?
And strike participation.
I think you could do, well, if you want to, well, let me say first, I think that this is about developing a plan, and that plan should talk about federal funding. So it's possible that federal funds are available for certain things, but not others. And so I'm not sure the allowable language is necessary to include in here, but if you want to, I think you could say something to the effect of federal funding or you could say available, something about available federal funding.
Okay.
So it could say shall address at least the following elements, go down to subsection C. Applicable federal funding, comma, including but not limited to.
So that's how we would start section 2C?
Yes. If you wanted to add that caveat.
Works for me.
All right, thank you. Thank you, Mr. Silverman. I really appreciate it.
Anytime. Thank you.
Thank you. Griffin, can you, whoops, yes, lead us on. And
So
Jen,
Griffin,
thank you for the timekeeping.
Griffin had to step away for a moment, so I believe next we have to speak is Representative Kermit Williams. Representative Williams.
Good afternoon. Thank you, members of the Education Committee. I'm not used to speaking to this group, but for 2 years, I and a number of other folks, both in the Senate and House side, have been involved in this issue of school bus driver authorization. When there was a problem with employment, it was very difficult to get school bus drivers. Now that we'll have a different set of issues going into the fall, I think a number of districts are concerned about being able to have the adequate supply of school bus drivers. They may have to have fewer kids per bus, so they may need more buses. There's a number of issues that really haven't been answered yet. But so I wanted to encourage you to pass the piece of legislation. I think it's section 32, which changes how school bus drivers are verified, authorized, the background checks and so forth, and to accept the Assistant Safety Commissioner's recommendations so that FBI background checks can be properly applied. What this does is it essentially changes how that work gets done so that it's done at a statewide level, so that if a school bus company has multiple contracts, the driver is approved once and can move from one district to another as necessary to be able to, for the company to be able to support the district's needs. So I think in a complex situation we're moving into, this is all more important, even more important than it was when we first started talking about this 2 years ago. Thank you.
Thank you, Representative. Any questions for Representative Williams? Thank you for your work on this section of the bill. Next. You think you're muted, Griffin.
Sorry about that. Sorry, our next speaker I have is Ken Norton.
Thank you, Mr. Chairman and members of the committee. And I will try to keep my remarks brief because much of what I had to say was covered by Mike Skibby and Michelle Winograd. I will say that I was not involved in a lot of the detailed work relative to this, and I applaud those that were. And my focus that I wanted to focus on was on Section 3A, the exclusionary discipline piece. And maybe I'm missing something here, but it requires school districts to go through A through F in terms of what they consider if they're going to expel a student. And I was struck that it didn't consider what the student's educational needs were or what the impact of the expulsion would be on that student, their family, and the community. And I think, again, given previous testimony relative to disability and racial inequities, that these should be considerations that are happening when a school is considering expelling a student for up to a year. I would also just mention an anecdotal case that I was aware of that NAMI was contacted on of an individual with a mental illness who had a medication change. He had no prior disciplinary actions against him. He was an honor roll student and he became suicidal as a result of that, potentially as a result of that medication change, brought a firearm to school, didn't threaten anyone other than himself, and was expelled for a year. So I think that the circumstances sometimes are really important to consider as well. Obviously, we all want to promote safety, but the seriousness of a year-long expulsion, I think, really deserves some further questioning about what is in the best interest of the school and the community. Thank you. I'd be happy to answer any questions.
Mr. Norton, you believe that this bill covers those issues, correct?
I do, but just wanted to say that piece in section 3, starting lines 3 and 4, where it asks for certain criteria for a school board to consider when they're expelling somebody. My question was whether they should also consider what that student's educational needs are and what the impact of that expulsion would be on that student. And maybe it's covered elsewhere, and I'm misunderstanding that.
But we don't have words to. I thought that the wording that it be appropriate for the student's needs is contained. I'm sorry, I'd have to. Without any specific reference, I believe that it's covered.
Well, it asks about whether a lesser intervention would properly address that.
Mr. Chair,
Yes.
Senator Ward, I think in section 4 at the end there, nothing in this section shall be construed to prevent the local school district or chartered public school that expels the student from providing educational services to such student in an alternative setting.
Thank you, Senator Ward.
Senator Khan, I'm sorry, I see Senator Starr's hand is also raised. I'm not sure if you'd like him to ask his question now, if you'd like to.
Well, Mr. Norton, do you mind hearing the next question?
No, I guess I would just say to, in my reading of that section that Senator Ward just mentioned, that makes it allowable, but it's not a requirement. And I would certainly hope that schools would want to provide educational services. But, and again, I'm not an expert on school law, but just questioning some of this. So sure, open to hearing the next question.
Senator Starr.
Senator Starr, when you're ready.
Yeah, the language I read in the bill was uncompromising. Possession of firearm was 1 year suspension, period, full stop, which seems a little harsh. As has been mentioned, there's got to be some cases where that's really unfair. And I would be in favor of softening up the language. Something like may be expelled for up to 1 year at the discretion of the school board. The way it reads right now is there's no discretion. 1 year, zap every time.
Okay. Thank you, Senator. I don't know if you have any comment on that, Mr. Norton. If not,
I don't.
Moving on.
Thank you all.
Our next speaker I have is Jake Berry.
Welcome, Mr. Berry.
All right. Good afternoon, Mr. Chairman. Let me begin by apologizing ahead of time. I have a dog, 2 children around here, and a neighbor who just began to mow his lawn. So hopefully you can hear me okay. My name is Jake Berry. I am the Vice President of Policy at New Futures. As you may know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. As part of our children's behavioral health program, we work in partnership with a diverse network of individuals and organizations to transform the way we support children with behavioral health needs in our state. We did submit written testimony, so I won't keep you too long, but I do want to express New Future's strong support for the provisions of this amendment related to student discipline and the children's system of care, and specifically the multi-tiered system of supports for behavioral health services. As you've heard over and over, the benefits of MTSSB are well documented throughout New Hampshire schools. Implementation of this framework has led to improved student attendance, reduced discipline referrals, increased family involvement, enhanced overall behavioral health, and improved academic achievement, among other benefits. The model has been recommended in the state's 10-year mental health plan, the Governor's School Safety Preparedness Task Force 2018 report, and most recently the Juvenile Reform Project's Keeping Kids in School report. Under section 27 through 31, this amendment would further empower the State Department of Education to support schools that are implementing MTSSB. This would help grow this important resource in schools around the state. Combined with the student discipline provisions of this amendment found in sections 2 and 3, this would go far to increase access to behavioral health supports in school at a time when they are desperately needed. And with that, I'm happy to take questions.
Questions for Mr. Berry? Thank you, Mr. Berry, for your testimony.
Thank you.
Let's see. As it stands right now, we have 5 speakers left. Our next speaker is Jeannie Ruska.
Welcome, Ms. Ruska.
Thank you, Griffin, Mr. Chairman, and members of the committee. My name is Jeannie Huruska, and I'm the political director for the American Civil Liberties Union of New Hampshire. The ACLU strongly supports the provisions of this amendment related to student discipline, and we echo the testimony by the DRC, NHLA, and New Futures previously who spoke on this section. We've been working with the Senate and this committee on student discipline reform over the course of the last year and a half, and are really grateful that you're including it in this amendment. I just want to take a minute to emphasize that we think the student discipline portion of this bill is really responsive to the moment that we are experiencing with regards to calls for racial justice across the state and across the country nationally. As noted by NHLA previously, data provided by New Hampshire schools to the U.S. Department of Education reveals that students of color are disproportionately subjected to exclusionary discipline here in New Hampshire. And such disparities are particularly troubling when considering the short and long-term collateral consequences of exclusionary discipline. Just by way of example, research has shown that being suspended even once is associated with being between 3 to 10 times more likely to become involved with the juvenile justice system or to drop out of school. So the racial disparities in the use of exclusionary discipline in turn contribute to similar disparities in those who enter the school to prison pipeline and to racial inequality in educational achievement. Over the past month, New Hampshire has seen unprecedented activism around calls for racial justice. And addressing racism in our state does include addressing its impact on our classrooms and on our students. And so in this pursuit, we really believe that the student discipline reform provisions included in this amendment will help reduce the disproportionate use of exclusionary discipline on students of color in New Hampshire, and couldn't underscore enough how timely this legislation is to the moment that we are all experiencing. So we thank you for your work on it and urge you to support the amendment and to vote OTPA on the underlying bill.
Thank you, Ms. Riska. Any questions from the committee? Seeing none. Thanks for your testimony today.
And just, Mr. Chairman, I do have one note, and I'm corresponding with Michelle, who's an expert on this. I wanted to respond to Senator Starr's concern about the issue of a student who brings a gun to school. And I just want to note that the issue of guns in schools is partly and heavily regulated by federal law. And the law allows superintendents to make exceptions on a case-by-case basis. So I think there are existing provisions that respond to the senator's concerns about, enabling considerations for the uniqueness of any one situation.
Thank you for helping us with that. I was going to ask somebody, make sure, did we looked up New Hampshire Ed Rules 317 to see the provision there, but I think you've helped clarify that, Ms. Riska. Thank you.
Senator Khan, I'm sorry, Senator Starr has raised his hand. Give me just 1 second. Senator Starr, when you're around.
Yeah, the language that I read in this bill that we're talking about now was just a flat 1 year suspension. No matter, in fact, it said 12 months, no matter what period. Now there might be some language buried deep in a wordy bill that's offices somewhere, but I didn't find it.
Yeah, I'm not looking, this is Jeannie, Senator. I'm not looking at the bill right now, but this is an issue that we have engaged the Senate on previously when SB 302 was taken up. And our sense, having reviewed it, is that superintendents have the ability to consider case-by-case situations.
I did not see that wording in the law we're talking about today.
Well, there is, sorry, but Ms. Riska, if I can direct you to Roman numeral 9, it's in section 2 of the bill. It's
Senator Khan, I don't know if this helps, but I might be wrong, Jean, but I think you mentioned that you had worked with Michelle Wangren on it, and she does have her hand raised. I'm not sure if you wanted me to bring her in as part of this discussion or anything.
I defer to Michelle, so that would be wonderful.
I will bring her in. 1 second.
Thank you, Griffin.
Yep.
Good afternoon. This is Michelle Wangren. So you're not going to find the language you're looking for in the current bill. It's in current law. So in RSA 193.13, section 3, it says any pupil who brings or possesses a firearm as defined in section 921 of Title 18 of the U.S. Code in a safe school zone without written authorization from the superintendent or designee shall be expelled from school by the local school board for a period of not less than 12 months. That is taken directly from federal law. It's a federal requirement as a condition for receiving federal funds to schools. Section 4 of the same statute, so RSA 193.13, says the local school board shall adopt a policy which allows the superintendent or chief administrating officer to modify the expulsion requirement set forth in that prior paragraph that I just read on a case-by-case basis. So federal law requires that the 1-year expulsion be the default, but it allows the superintendent to modify that default requirement on a case-by-case basis. And that requirement of the superintendent is also found in federal law.
I knew that was somewhere. Thank you. Further questions? Thanks for helping clarify this.
You're welcome. Thank you.
Oh, let's see. Next speaker, Gerald Zellen. Give me 1 second. Gerald, go ahead.
Thank you. Can you hear me now?
Yep.
Okay. I'll be brief. First of all, pardon me. First of all, I oppose Senator Khan's amendment insofar as it reiterates what the House version of House Bill 1588 provides, which is to increase the maximum age of eligibility for special ed from a 21st birthday to the 22nd birthday. On the other hand, if you were to amend the law to increase that age limit, then I support the provision in Senator Khan's proposed amendment that would postpone the effective date of that change in the law to July 1, 2021, because school districts have already adopted budgets that did not take into account the passage of a bill that has not yet been passed. I would only add one more thing, that I have a copy of the 1991 New Hampshire Board of Education state rules, and they identify in 1981 a child with a disability as, quote, 3 years of age or older, but less than 21 years of age, unquote. And that echoes what RSA 186C said, enacted in 1981, and it echoes what the predecessor statute, RSA 186A, said when it was enacted in 1975 to implement the IDEA. Thank you.
Thank you, Mr. Zellen. Any questions for Mr. Zellen? Thank you again for your testimony.
All right, we have 3 more speakers. Robert Bevel coming up next.
Welcome back.
Yes, sir. Thank you. I had to go take care of the kids for a little bit. Had to come back. Thank you. I originally was objecting to this amendment specifically for the fact that it was all being packed onto the bill that I proposed, the House Bill HB 1558. But after hearing the testimony today and the thought, I understand that lawmaking is the process of making sausage. And so I understand that's kind of what you have to do to get all this through. So I withdraw my objection to it, because apparently, Senator Khan, this is how you get it done. And thank you very much.
Thank you. So your indication, we usually record people's support or lack of opposition. Would you like us to then correct that and record you as in support of the amendment?
Yes, sir, that would be fine, because again, I was just concerned that that was a lot being packed in here. However, apparently staff have done a lot of homework on getting this in here so that all these bills can be included and it will not affect the original bill. Thank you.
Thank you, Mr. Bevel, and your acknowledgement of the staff is absolutely seconded by all of us here.
Thank you.
You're here without them. Thank you again. Next.
Mark, let's see, I believe it's Mark Rapuso, I think. Give me 1 second. Mark, whenever you're ready.
Yes, Mark Raposo from the New Hampshire School Transportation Association. We are an association of both private contractors and school districts. Chiming in on the school bus driver criminal background checks that we've already heard from the director and from Representative Williams. We've worked very closely with Senator Kavanaugh, Senator Susie, and Representative Williams on this. We're strongly encouraged that this passes. What we really need is to have a criminal background that is statewide. The current process is done by district. And as we know with Northwood, that created quite a problem. And as Representative Williams mentioned earlier, the situation that we're in right now, we know coming out of it, we're going to have even less bus drivers than we did going in. So although this probably won't help us in the immediate future, it will help us down the road. And I highly hope you support this. Thank you very much.
Thank you, sir. Any questions? Thank you. Thanks for your testimony.
And our last speaker is Barbara Slayton.
Ms. Slayton, welcome.
Unmute. Can you hear me?
We got you, Barbara.
Okay, thank you. I submitted some written testimony as well, so I won't repeat that. My name is Barbara Slayton. I'm the coordinator of school wellness for the Franklin School District, and I'm just called in to support the MTSSB portion of the amendment. We are a school district that has had the ability to implement MTSSB. Thankfully, we had a piece of a Project Aware grant through the Bureau of Student Wellness. So we've had that technical support and also the financial support to implement that. That funding has gone away. We've seen tremendous positive results from implementing the MTSSB, many of which have been talked about earlier here by the earlier speakers. So I'm just chiming in as a representative from a school that's actually doing it. We want to continue to be able to do that work, and the support and the structure provided by this bill and any funding that goes along with it, or funding to support the Bureau of Student Wellness in supporting school districts across the state will be beneficial to all of the students.
Thank you, Ms. Slayton. Any questions for Ms. Slayton? Thank you for your work and for your testimony today.
Sorry.
Okay.
At this time, I don't see anybody else who wants to speak. So unless somebody wants to speak, they can raise their hand or press *9 on their phone. But aside from that, I don't have anybody else.
Right. If there is nobody else requesting to speak, we will be closing the hearing on the amendment to 1558. Seeing no further discussion, we will close the hearing on the amendment. Thank you. We will now open a hearing on House Bill 1582. I hope Representative Roy is still with us.
Just bringing him in now.
Good
Looks
afternoon.
like he's live from the State House.
Good afternoon, Senator. I am here.
No, thank you. Would you please, we would like you to introduce House Bill 1582, please.
Thank you. Thank you, Chairman and fellow senators. I have the distinct pleasure this afternoon of introducing this bill. House Bill 1582 was born of cooperation with various veterans groups throughout the state who expressed an interest in a troubling situation that we had. Currently, the statute in New Hampshire is that if a veteran or a service member dies in service, their children are unable to attend state colleges and universities free of charge. However, if a veteran is 100% disabled while in service, there's no such assistance given. And it puts them in a horrible position of their children, unfortunately, being better off had they not survived their injuries. And since the original statute was in place, medical technology has advanced really far. So injuries that used to would be most certainly fatal to a service member, such as losing their legs or to an IED or such a thing, they're surviving these things. And they're coming back and they're 100% disabled, but with catastrophic injuries. And the pension for a disabled service member who's 100% disabled is about $3,000 a month, which makes it next to impossible to put a kid through college. So we looked at this and decided, you know, this is something that we can help them out with. So we worked closely with the college system and the university to try and narrow this bill, fine tune it so it applied just to the people that we wanted to help. So it's 100% disabled veterans, service-connected disabled veterans. That means that the injury had to be related to their service. They have to be New Hampshire residents at the time they're declared to be disabled. We limited the age of the students to 26 so that we didn't have older veterans' children coming back to get their MBAs and things like that. So we really fine-tuned this thing down as fine as we could to keep the expenses down. And with the assistance of various veterans organizations who really did a lot of work on this, pulling numbers together, it came to be about 127 students potentially per year that would qualify for this. Now, that's not 127 who would be definitely going, it's just that they would qualify for it. So we got it narrowed down as much as we could, and then we even narrowed it further by requiring anyone who applied under this statute to fill out the FAFSA grant forms, so that the colleges and university systems will be able to recoup the money that they are allowing the student to go for free from the federal government and grant programs that are available to them. So we tried to make this as revenue neutral as possible, and get it as narrow as possible, yet be able to help those who served and sacrificed everything for us. And so that it is no longer the situation in New Hampshire where their children are better off had they not survived their injuries. In the meantime, actually last night, I discovered that the university and college system had some reservations with the bill now after having been for it, and they're going to encourage the Senate to put it into a study committee, which means actually kill it. And they cited financial concerns. My issue with that is that we've looked at it and we've narrowed it down so that it's almost financially neutral, if not actually beneficial, to get people in seats that they wouldn't otherwise be in. They cited the COVID issue. However, they're receiving 15 million from the governor, who's allocated 15 million to the university and college systems for COVID, and they're receiving another 18 million directly from the federal government. So we're really hoping that we can push this through. It's not going to cost a lot of money, if any. And I don't think that we should be looking at this as a way to save money because of this temporary COVID thing. If we were to push it off another year like they want us to, we're talking about a whole age of kids who aren't going to be able to plan their future or start college. I just don't think that a temporary financial setback like this is something to put this off. Much like your previous bill, this bill was voted out of committee unanimously in a bipartisan manner and sailed through the House as part of consent on a voice vote. And as you know, in this current climate, for something like that to happen, that tells you that, you know, the people of this state want this to happen, because 400 of their representatives who don't agree on much agreed on this. So that's all I have, and I'd be willing to take any questions.
Thank you, Representative Roy. Any questions from committee members? How did you determine the 127 eligible?
So I'm not sure if anyone from the VA is, or the Veterans, New Hampshire Veterans is on here, but I'll take a stab at it. They did most of the legwork on this. What they did is they went to the VA and they asked them and narrowed it down. How many 100% disabled veterans are there in New Hampshire? How many of them are of the age where they would actually have college age or younger students? Because the vast majority would be Vietnam era vets whose children would be aged out by now anyway. So we narrowed it down as fine as we could based on the information we were able to get from the VA and the state veterans organizations.
Yeah, thank you. I guess I'm sort of just, this isn't a means tested, while there's the FAFSA is required to be formed, there's nothing that says that the student needs to demonstrate financial need, which by filing the FAFSA would do. Is that a possible thought here? I hadn't really considered that until I heard the numbers here, and but there actually is a requirement in this bill that says that they will cooperate with the College Financial Aid Office in completing that. If upon completing it, it is found that there is financial need, this could apply to those students. Any comment on that kind of option?
Well, what we looked at was that we considered that the vast majority are just by virtue of one of their parents at least being 100% disabled. They would probably more than likely qualify for some type of financial aid under FAFSA. But getting into whether or not there were a few who would be considered not eligible for FAFSA, we'd be looking at creating another bureaucracy and trying to vet those people and chase down their financial abilities and things like that. And we determined it would be so small that it really wouldn't be effective to the bill.
Okay. Any other questions of Representative Roy? Representative, thank you for bringing this forward and presenting it to us.
Thank you for taking the time to hear me.
Griffin, how many people do we have that wish to testify in 1582?
4 total. Our next speaker would be Representative James Allard. Give me 1 second.
And we do expect an amendment to be introduced, so just hopefully they're speaking to the bill.
Yep, I believe Representative Allard will be speaking to the bill, but I'll let him say
Welcome,
that.
Representative Allard. Thank you.
Thank you, Senator, and thank you, members of the committee. I certainly can be brief since I have followed the eloquence of Representative Roy. But I wanted to come here this afternoon and voice my unwavering support for this bill, as I was the member of the House Education Committee that chaired the subcommittee that worked through the issues ultimately to create the amendments that were vetted through all of the stakeholders, including the universities, who now seem to be having second thoughts, and then took this to the full committee, as Representative Roy has said, getting it through in a 19-0, and as Senator Khan has seen on many occasions, any consensus like that in the House Education Committee is rare. But then getting it through the full House with a voice vote. This is a bill whose time has come. This is a bill that allows our state to, in fact, to honor the sacrifice of those that find themselves 100% disabled in our service. And so that is really my sole purpose for today in stating that this is a bill that is not going to be of great financial challenge to our state, because there are so few who qualify, and the bill itself has worked through and made provision for those fiscal questions. And so speaking for myself and House Education, we support this and would like to see it succeed.
Thank you, Representative Allard. Any questions of Representative Allard? Thank you. Thanks for your testimony.
Thank you, Senator.
Next speaker is Colonel Warren Perry.
Good afternoon, Chairman and members of the Senate Education Committee. My name is Warren Perry. I'm the Deputy Adjutant General from the Department of the Military Affairs and Veteran Services. I would like to just say, first answer Senator Kahn's question about how we determined the 127 number. And essentially we kind of interpolated or based on the population of New Hampshire and the percentage of 100% permanent total in the population of New Hampshire that might have college-age children. And we took that percentage and compared it to the percentage of people who attend attend school either in the university system or the community college system. And we kind of worked that percentage down to anywhere between 90 and 150 that would be eligible for this benefit. And we kind of settled in that 127 range as a good number on any given year that would be eligible or based on the number of people going to school to take advantage of a benefit if this passed. So I hope that answers the senator's question.
Thank you.
I would say that the department takes no position for or against this. We do think it's a good idea if it's possible. But certainly, I think it bears some further consideration, based on what might be a changing fiscal situation for the state. So, we don't support it. We're not going to say that we support the bill or not support the bill, but I do think that the conditions have changed with the fiscal situation in the state since we heard this bill the first time. So with that, I'll be happy to answer any questions.
Questions of Colonel Perry? Colonel, thank you for your service.
I'm sorry, I don't mean to cut you off. Senator Starr raised his hand. Give me one moment.
Senator Starr.
Senator Starr?
Yeah, I just wanted to say, speaking as a veteran myself, we certainly ought to offer education to the children of disabled veterans on the House. We can afford it. Thank you.
Okay.
Our next speaker is Kevin Grady.
Mr. Grady, welcome.
Thank you, sir. For the record, my name is Kevin Grady. I'm a 20-year resident of Hooksett and a 25-year Air Force veteran, and today I'm here representing the State Veterans Advisory Committee. We strongly support this bill. We strongly support the legwork that was done behind the scenes to try and align this as much as possible with the federal statutes and provide as much ability for the state to recoup some of that money through grant programs and other things. We feel strongly that when one of us serves, that person's entire family serves. And because of that, we support bills like this, which we think, as has been mentioned by all the other speakers, is going to be small amounts on a yearly basis. And we understand the current fiscal environment that our schools and universities find themselves in, but we feel that that is going to be a temporary thing. Even if it turns out we're going to end up doing a lot more distance learning, online education, I believe that the school system will adapt to that over time and will get back to equilibrium. So I don't think we should let the short-term issue that we have now with COVID-19 situation we find ourselves in impact the longer-term outlook for this particular bill, which we think is overwhelmingly positive for that small percentage of folks that have had their lives forever changed by their service to our country. And if you, for economy of everything, if you'd like me to address the couple three issues, or not issues, but my support of part of the amendment, I can do that now, or I can wait till we talked about the amendment. It's up to you.
No, we'll save that for the amendment. I'm sorry.
Yes, sir. Fine.
Any questions of Mr. Grady? You'll get another crack at him, I think. Thank you, Mr. Grady, for your testimony.
Thank you, sir.
Our next and final speaker for House Bill 1582 is Tom Cronin.
Welcome, Mr. Cronin.
Thank you, Mr. Chairman, members of the committee, Representative Roy, Representative Allard, Colonel Perry, Mr. Grady, thank you for the time to talk on this today. I think our concern has been summarized by some of the folks that spoke before us, but I think by way of just a little bit of background, obviously, we were happy to work with Representative Roy, Representative Allard as the chair of the subcommittee in the House on this legislation to, I think, really tighten it up and improve it to the place it was in now. But I'm sure as the fact that we're doing this hearing as we are now, compared to when we were all sitting less than a foot away from each other in the House working on this legislation, you all can appreciate that things have significantly changed over the course of the last couple months. I submitted written testimony that I think kind of outlines our two major concerns, but I'll really just quickly say the two issues that we had hoped and expected to work on more over the course of the last couple of months through the Senate were first this interplay between state and federal benefits for this population. Currently under VA Chapter 35, the population of students we're talking about here are eligible to receive, I believe it is about $1,200 a month for between 36 and 45 months of educational benefit. So they are getting at this point a significant benefit from the VA. And we wanted to be sure that as we enacted a new benefit that was going to be paid for by the state, that there wasn't going to be any sort of confusion or conflict between that federal statute and those federal benefits and what we were hoping to offer at the state level. And then second, most concerning for us, and then I think this was a concern as we worked on it in the House, and as folks have mentioned, the COVID crisis and the fiscal issues and the fiscal strain that is put on both the community college system and the university system have just heightened that, is the question of how many students are going to be eligible for this benefit. As you heard Colonel Perry say, the data we had was simply how many veterans there are in the state of New Hampshire that are permanently and totally disabled. We don't actually know how many students or how many children those veterans have. We don't actually know how many of those children would be of college going age. And we don't know how many of those children are already attending college. Those are some pretty significant unknowns that we tried to come up with a number on. I think the fiscal note that's still attached to this bill is indeterminable. If we were under the regular timeline, we probably would have submitted a fiscal note of about $1 million a year for the university system, but with significant caveats to that, to say that this bill could certainly encourage a number of students who are attending out of state to now decide to enroll in state for free. And by for free, I mean certainly paid for or subsidized by the university system and the community college system. And those were really just, those again, were concerns we had as we worked through the House and concerns that are heightened now given the financial impacts of COVID. I think one important thing I'd just like to point out too, certainly this is a population that we want to be supportive of. The testimony goes into a number of the different programs that the university system and community college system currently have and currently finance on our own in support of our military and veterans population. I believe we're supporting two other bills that are coming up as part of the omnibus amendment after this. For these students, particularly the ones whose parents are simply living on a $3,000 a month pension, programs like the Granite Guarantee at the university system, significant financial aid through the community college system are ensuring that these students are already able to attend public higher education in the state for little to no cost if they are significantly needy.
Excuse me, Chairman Khan, Mr. Cronin's time has expired.
I will stop there and be happy to take any questions. Thanks, Deb.
Thank you, Mr. Cronin. Thank you, Deb. Any questions for Mr. Cronin? guess were you to do a revised fiscal note, it would be that your estimated cost here is $1 million. Is that?
That is about where we were going to settle on the university system side. I don't know what the community college system side was going to come in. I think Shannon was hoping to be on this call, but had to jump off. So I don't want to speak for them. And again, it would have been caveated by significant unknowns.
Yeah, I mean, isn't this one population that has about 127 people to it that might go to the community college versus the university?
So as Colonel Perry suggested, what we know is there are a certain number of permanently and totally disabled veterans in the state. That is the extent of what we know. We came to that number, the 127 number with the high of 150, low of somewhere in the 90s, based simply on trying to do math by saying, of those, we know from demographics that that number of people should have this number of kids. Of those number of kids, demographics would suggest that number of kids are this age. So again, we have no way of knowing, in fact, how many kids there are that would qualify for this benefit until we essentially open up the floodgates to allow whoever wants to partake in it.
Okay, thank you.
Thank you.
No further questions? Thanks for your testimony.
Yep, sorry, I muted myself. While I don't have anybody else to speak, Representative Roy does have his hand raised. Believe he might want to provide a few more comments.
Thank you. Representative Roy.
Thank you. If you'll allow me, I just wanted to respond to a few things that the university said. The VA does provide a $1,600 a month benefit to children of 100% permanently disabled veterans to use for education. We discussed this at length in at the committee level in the House, and the university system agreed with us at that time that that was federal money and could not be earmarked by the state. And furthermore, since we were not waiving fees or books or anything of that nature, just tuition, the children would need that $1,600 a month just to be able to survive at college. And we didn't want to touch that. And they were in agreement with that at the time. And just a final note, what they're saying is put it off because we don't know. Well, it's unknowable. We will never know. There's no way to actually know. We came up with the best numbers we possibly could. And there's just no way to get an actual number. It's impossible to do that. And I understand the burdens on the college. I also understand that, every biennium they come to us for millions of dollars and we give it. And this past biennium, we raised their income by $12 million over 2 years, over two years. And it's very rare that we come to them and ask for something. So just keep that in mind. We're asking for something for a change. And I really am discouraged by the amount of pushback I'm seeing. Thank you.
Thank you, Representative.
I'm very sorry, Senator Khan. Colonel Warren Perry has raised his hand. I believe he probably wants to add a couple more comments as well.
Okay.
Colonel Perry?
So I would just let you know that I emailed the analysis math to Griffin so he could share that with the committee on how we got to the 127. Thank you.
Thank you. All right, Griffin, are we there?
I believe we're there. I think we're good.
Well, then in that case, I will call upon Senator Morgan. Let's see, we'll close the hearing on the original House Bill 1582 and open a hearing on an amendment to House Bill 1582. Senator Morgan, would you care to introduce your amendment?
Yes, thank you, Mr. Chairman. If you'll just give me a moment.
I have amendment number 1327. And I believe that if people are following the calendar, you will find that on page 249. And we have the base bill plus.
Yeah, so thank you, Mr. Chairman. The purpose of amendment 1327S is to include language from the full bill from the Veterans Bill of Rights that passed the Senate unanimously to House Bill 1582 FN and also does not should not impact the current language that was just previously discussed. I'm sorry.
Oh, sorry.
And should not impact the language that was just previously discussed. So this is an add, not a change all, if that is helpful. So, Mr. Chairman, in summary, we've already seen virtually all of this language in previous legislation in this committee. This is a review of that same legislation, in addition to what we just heard from on House Bill 1582.
Right. So much of this is Senate Bill 421, I recognize. Incorporated within. Okay. Thank you for your introduction. And do we have people who are interested in speaking to this?
Yep. So Senator Morgan spoke, I believe. Colonel Warren Perry has signed up to speak on this one.
And Senator Khan is at Senate Bill 726, just to be.
Yes, of course, in 726. Thank you.
I apologize. I looked to the attendees list too fast. Senator Starr has his hand raised. I think he might have a question. 1 second.
Senator Starr.
Senator Starr.
Yeah. The basic bill is a good one. I was kind of appalled. This amendment seems to set up a training program for a special group of navigators who presumably will, the paperwork for getting your veterans benefits has gotten so bad that the veterans can't handle it, and so we're training up a special group of people to help them do the paperwork. I suppose it might be necessary, but why don't we simplify the paperwork so it's not so bad, rather than setting up essentially more bureaucrats to consume time and money and slow things down. Thank you.
Thank you, Senator Starr. Just a couple of things. Most of that paperwork is federal and we don't have jurisdiction on it, number one. Number two, this is previous legislation through Senate Bill 726, on which I believe you've already voted in favor. So just a reminder.
Yeah, it's, we're writing state law, not federal law.
That's the point. Yep.
Okay. Do we have anything else, Senator Starr?
No, that was just my comments.
Moving along here, Griffin.
Yep, I got Colonel. Just two. I had Colonel Perry and Kevin Grady. I'll call Colonel Perry first.
So good afternoon again. For the record, Warren Perry, Deputy Adjutant General, Department of Military Affairs and Veteran Services. Just wanted to note that the department is certainly has no objections to this amendment. We were in favor of it when it went through committee the first time. Just want to point out in section 15 on page 254 of the Senate calendar that that our department, unless this is funded in budget, there's an appropriation to take care of the fiscal note that we attach for the 3 people we need to do the things we need to do. It doesn't take effect until we get some funding to do that. And we appreciate Senator Morgan's willingness to work with us on that language to make sure that we didn't have mission creep beyond our capability. there were some other sections of the bill that deal with the post-secondary assistance in education. That's the law, the RSA that deals with providing tuition-free education in the university system and community college system of New Hampshire for members of the New Hampshire National Guard. And we're happy to see that this is continuing to move through this changes to that part of the statute are continuing to move through the legislature, because it's a very important part of enabling the National Guard to accomplish its mission and keep its ranks filled. Pending any questions, that's all I have. Thank you.
Mr. Perry, Colonel, I wanted to ask probably on the last bill as well, but I noticed that in this act, we have effective date of July 1, 2021 on the base bill for disabled veterans children's benefit. We have 60 days after passage. If all of this would, because of the dates that we've got, and, it's kind of anyway, the tight timelines. Any objection if we make this entire bill effective July 2021?
I have no objection to that, but again, the base bill has no effect fiscally on the Department of Military Affairs and Veteran Services, only the university system. The reason of the effective date of July 2021 was we didn't want to drive an appropriation in the middle of a biennium. So that's my recollection. I think Senator Morgan can probably speak to that better, but we have no objection to the effective date change, whatever happens with the effective date.
Relative to all sections of the bill?
That's correct. Oh, I'm sorry. We would love to have section, I'm sorry, I misunderstood your question, Senator. I apologize. For sections 16, 17, 18, and 19, we would love to have that effective 60 days after passage. Because it impacts our ability to recruit effectively immediately, and waiting till July of 2021 will delay our ability to fill our ranks. So if that was your question, I apologize, I misunderstood.
And what about the previous sections of the bill that we just heard?
So from my perspective, just to be clear, sections of the amendment, I'm talking about the amendment now, sir.
Yeah, I know, but it's section 1.
Section 1 through 15.
I'm messing this up, but yeah, section 1.
So section 1 through 15, we have no objection to whatever date is put on the bill for sections 1 through 15. Again, our rationale, I believe the rationale was to begin the effective date of these programs in conjunction with the start of a biennium. For sections of the amendment 16, 17, 18, and 19 of this amendment, we would like those to take effect as soon as reasonably possible. I think the original bill for that, for the original legislation had it 60 days after passage. I hope I clearly answered your question.
You did. We'll no doubt discuss this further. Thank you, Mr. Perry.
Thank you, sir.
Others next? No further questions. We'll move on to the next.
Let's see, our next and final speaker is Kevin Grady.
Thanks very much. Again, for the record, my name is Kevin Grady, a 20-year Hooksett resident and 25-year Air Force veteran representing the State Veterans Advisory Committee. We do strongly support the amendment. It really brings in 3 things that are on our list of bills that we were following. The majority of it, of course, is Senate Bill 726, the Veterans Bill of Rights, but also Senate Bill 421 about the veterans' access to the university system by, number 1, taking the space available restriction out, And that just aligns it with what they're currently doing in the university system anyway. There hasn't really been an instance where a member of our National Guard went to a college and they said, well, there's no space in the class for them. So they were all in favor of that when we had the House bill. I'm hoping that is still the case. And it also allows our National Guard folks to, as soon as they've signed on to the Guard and they start attending Guard meetings and those kind of things, they can actually go and take our classes. And we like that idea because in the environment we find ourselves in, it may be a while before some of these people are able to actually go to the training and the follow-on training, but they're still members of our team. There's also Senate Bill 455, which is the discrimination bill. And that went through committee and we talked about it. It was amended to say that to prohibit discrimination, but that if the university system, for example, wanted to give preference to somebody, if they had two equal applications and they wanted to give preference to a veteran, or they wanted to give preference, say, for a class on law enforcement to a law enforcement officer that's going to enter the system, then we would support that. Other than that, sir, I yield the floor back to you. And I do appreciate everything that you're doing to provide this online and move the people's business forward. I really do appreciate the opportunity to make sure that things keep getting done in the times we find ourselves in. So thank you all for that.
Thank you, Mr. Grady. And again, thank our staff for making this possible. So if there's no further testimony or questions of Mr. Grady, no further testimony.
I have no further testimony from anybody and I don't see any hands raised, so.
Okay. And if there's anybody who wishes to express themselves on this question of this act, appreciate the testimony from Mr. Perry about 15 through 19, but the implementation dates, I think, are.
Tom Cronin has raised his hand.
Yes.
Thank you, Mr. Chairman. Sorry, Griffin, I think I had some confusion when I was registering. I just wanted to quickly express the university system's support both for Senator Morgan's bill as well as the Guard waiver provisions bill. We are happy to work with all the parties involved on both of those. We're supportive of whenever the committee decides on those effective dates. We're happy to make them work, whatever works best for the Guard and for the committee. Obviously, we've already registered our concerns about 1582. I did also want to just take a quick moment to, again, register our objection on Senate Bill 455, that underlying legislation having to do with non-discrimination policies. You remember we brought these concerns when the committee first heard this bill. We are happy that the law was amended to correct, I think, the sort of oversight that would have prevented us from giving preferential treatment to veterans, but would still note two things. One, veteran status is already a protected status in federal law. We don't think it is necessary to create another state law that is duplicating what is already existing in federal law. And second, law enforcement status, on the other hand, is not a protected category under either state or federal law. We think adding that, particularly adding it just to the community college system and the university system statute, is going to create ambiguity in the state statutes. It's our position that if this committee and if the legislature wants to create a protected category for law enforcement personnel, that it's something that should be done in the labor statutes and not one that would basically create a protected class of employee just for our two employers in the state. That's all I had. I'd be happy to take any questions. Thank you.
So I want to make sure we understand sections 23 and 22 and 23 of the amendment contain what was Senate Bill 455. Are you suggesting that your opposition to those two sections of this amendment, of Amendment 1327?
Correct.
And if I can ask you what I probably should have earlier, relative to section 1, if the implementation date on that was made effective July 1, 2021, Does that allow the university system opportunity to consider fiscal implications of this further and
Yeah, thank you, Mr. Chairman. I think that is something we would be comfortable with. It would give us the time to continue to work through this as we are committed to doing regardless, and would give us some time to come back to you all and address any concerns that might arise. And it certainly will be in a budget year again at that point. And I think to some of the comments that were made, it'll give us all a good chance to see sort of what the real fiscal picture looks like going forward. So I think I want to be cautious. I have not run that by anybody at the university system, and I don't want to speak for the community college system. But I think if we were to push the effective date of 1582's original provisions out to July 1 of 2021, that's something we would probably be comfortable with.
Thank you. Griffin, we have no further hands up.
Shannon Reed has raised her hand. Give me 1 second.
Hi, good afternoon. I just wanted to respond to your question, Mr. Chairman, about pushing the effective date of that section out. That's something that we would be comfortable with. My primary concern with that portion with House Bill 1582 is that I had not had time to run the House passed language past our financial aid officers so they could better understand how this will work in their universes as they deal with our veteran students and students who come to us with benefits that are related to veterans population. So that would give me time to make sure that background work is done and our folks know that this is coming and they can be prepared to work with these students in that new way.
Thanks for your testimony. Any questions from Ms. Reed? Seeing none. Again, thank you.
That concludes all the testimony and hands. Our next bill is, I believe, House Bill 1454.
Officially, we'll
Oh,
close
sorry.
the hearing. Yeah, sorry.
Yeah.
We'll close the hearing on amendment 1327 and open the hearing on House Bill 1454. Prime sponsor is Representative Tanner.
Representative Tanner?
Yes, good afternoon. Can you hear me?
Yep.
Thank you. I'm Representative Tanner. I represent Sullivan County District 9, and I'm the prime sponsor of this bill. This bill was set up as probably you're all aware of, and certainly you were with me yesterday in the House Education Committee, was set up because there was a Learn Everywhere proposition coming from the State Department of Education that required school districts to accept 1/3 of their graduation credits from extended learning opportunities that the state school board would approve. And my feeling is from the statute and also from a practical standpoint and a safety standpoint and a few other standpoints, that the credit for graduation from extended opportunity learning opportunities should stay with the school. So this bill basically is very simple. It just says that graduation credits are approved at the local level, period. And it's not that we don't think extended learning opportunities aren't wonderful. Back in the day, I actually took an extended learning opportunity to Australia on a Rotary exchange for my senior year in high school and went through my local school board, and they approved it and approved credits coming from there. So if you work with your local school board, most extended opportunities are accepted. I also think that in many schools, there's an ELO coordinator, and that's very important to make the connection with the community opportunities, the people that run it for safety. They oversee the project to make sure that the student is dealing with the situation and the employer is dealing with this situation, and provide assessment goals and grading for the person to receive credit. So that's why I've proposed this bill, and it passed in our House. It actually mirrors a bill that passed in the House and Senate last session, but was vetoed by the governor. And I'm open for any questions.
Thank you, Representative Tanner. Representatives, because we know that we will entertain an amendment to this bill. Have you reviewed Senate Bill 514?
I certainly have. I've went through the whole testimony yesterday as the clerk and typed it up this morning, so I'm very familiar with it. I think it's a great addition to this bill. I strongly support it. I think it clearly defines the role of the local education association to give the credits, the graduation credits, but it also tells about the role of the state school boards to try to open up opportunities and encourage resources and vet vendors to develop a list that local schools can use. And my superintendent in Sunapee, I had a conversation with him, and this is exactly what the superintendents would like to see.
Very good. Well, thank you. If you are still here when we get to the amendment and feel so compelled, you just obviously Griffin's watching the crowd. So
Well, you're having a long day.
we're doing good work, I think. I think we're making.
Yes, you are.
So thank you. Any questions for Representative Tanner? Seeing none, Representative, thanks for your work.
Thank you.
I do not see anybody with their hand raised. I believe Representative Tanner was the only one to register to speak on this bill.
Very good. If there are.
Oh, I'm sorry. Commissioner Edelblu has raised his hand.
Commissioner Edelblu. Hello.
Hi, good afternoon. This is not Commissioner Edelblu. This is Greg Fossey, the Communications Director for the Department of Education. The Commissioner had planned to speak with you this afternoon. He had another call that he had to jump on right at 4 o'clock, and obviously you guys have had a very long afternoon. So he apologizes for that. He has submitted some testimony and he had some remarks he wanted to make today. If you'd be willing to let me deliver those into the record.
Certainly.
Thank you. First of all, again, I apologize that the Commissioner was unable to stay on, but I am delivering testimony for Frank Edelblu, Commissioner of the Department of Education. My name is Grant Bosse, B-O-S-S-E, and I am Communications Director for the Department of Education. Students who have learning opportunities outside of the school building, whether in a community setting or one of New Hampshire's great businesses, benefit tremendously. This is particularly true for our economically disadvantaged students. This benefit has been validated by 2 studies by the State Board of Education, one in 2011, the other in 2014. For over a decade, schools have had the responsibility for these out-of-school learning opportunities to students. But in spite of this responsibility, today only 3% of students get them. We think this is wrong. 3% number, to let you know where it comes from, represents the data that the schools themselves have provided. In January, the Commissioner met with the ELO coordinators, presented them with their own information and validated it. The ELO network came back and said, yes, it's a good number. And what that means is that schools, for whatever the reason, are not providing the students with these ELOs that we all seem to agree are a great opportunity for students. Learn Everywhere is a program that will do 2 important things. First, it'll open up these outside of school learning opportunities for New Hampshire students. And second, it will allow the department to come alongside our districts to create these opportunities for students to meet their responsibility, an alternative path as the current statute mandates. Yesterday in the House on a similar amendment, the NEA testified that programs could not be run because they may or may not have a certified educator as part of the program. This is not true. The department specifically included certified educators in the program approval process. And beyond that, does anyone actually believe it's not possible to learn from somebody who isn't a certified educator? We've all learned a lot that we know in life under circumstances that happen outside the classroom and without a certified educator. It doesn't diminish the role of the educator, but simply points out that it's not an exclusive role. HB 1454, as it would be amended, would prohibit the implementation of Learn Everywhere and rob disadvantaged students from community learning opportunities. The Commissioner urges the committee, for the sake of these students, to reject this bill, reject this amendment, and allow the Learn Everywhere program to move forward. Thank you very much for your time, Senators.
Thank you. I assume we'll not have that opportunity of asking questions, so thanks for delivering the testimony, Mr. Bossy.
Thank you very much, Mr. Chairman.
That concludes everybody I have for this bill. That's all I got.
Okay. Well, seeing no further testimony, I think we can close the hearing then on House Bill 1454. And I'd like to open a hearing on an amendment to this bill, number 1348. I'd like to recognize Senator Deitch.
Thank you very much for your patience and hanging in there, everyone. This is SB 514, and it is being put in as an amendment on this bill. What it does really is tries to combine what the state is trying to do, the DOE is trying to do, with local quality assurance. So what this bill does is to set up and let and actually require the Board of Education to put together the list, to vet the applicants just as it wants to do. The only difference is whether this is a mandate for districts to accept credit or a list of suggestions and recommendations for the districts to choose or not choose. I did want to suggest that we do a committee amendment on this on line 3. I think we got a little carried away with the deletions here. So I would like to, on line 3, undelete the words adopt rules, comma, pursuant to RSA 541A, comma, undelete that, and then insert one word, THAT, that. So it would read, the State Board of Education shall adopt rules pursuant to RSA 541A that establish a process for the application and so on. So that's what I'll be asking for, but I do want to speak a little bit more because I think there's a gross misunderstanding of what we're trying to do here. The idea that we are robbing disadvantaged students by telling their schools that they don't absolutely have to accept the state's suggestions, I think is a gross misleading of what's happening here. 1348, it amends RSA 193E to a VB in order to broaden opportunities for students, yet it's trying to do what the original bill was trying to do, and that's to maintain those connections among students and parents and schools and businesses in the local community. This amendment's designed to clarify the legislative intent of RSA 193 E2AVB as we've been asked to do by the joint resolution. And this bill requires that DOE create the rules just as it wanted to identify vendors of alternative extended learning and works-based programs. This goal is to provide diverse options that to fit the needs of diverse learners, including the disadvantaged students. And the proposed DOE rules, the way that they have suggested that this process will work. And this is very important. Understand that the process for approving an applicant is that they submit a form and describe their program, and the State Board of Education approves or disapproves the applicant. This approval lasts for 3 years, unless there are complaints about this vendor. So this is the sum total of oversight. This is it's very high level, very hands-off, very distant kind of oversight. There's no personal connection. So Amendment 1348 does not change that process at all. All it changes is that the credits from some such program may be refused by a district. A district typically perform a much more in-depth review of programs than the state's approval process that they've defined. Amendment 1348 allows them to decide that the program does not meet their standards. So I'm going to go through what a typical district will do. So a district quality assurance, it's much more personal and more rigorous than the state proposed approval. A regional or district level extended learning, they're extended learning coordinators. They may be right in the district, right in the school. But for schools that do not have those on-site ones, we now have regional coordinators available, and they can help with this process. So what these coordinators do is they match students with opportunities. They get to know the student. They intercede. Once the student has started the program, they intercede if problems arise. And they help out if the student is in an internship situation and is a little uncomfortable, or maybe isn't behaving properly, and maybe the business is complaining about the student. They intercede and work with the student so that he understands what work standards are. This kind of hands-on relationship is very different than the state board approving something. And I want to tell you that I come from the educational media industry, and I have been a consultant, a market consultant for the educational publishing industry. I know this industry very well. Without Amendment 1348, without this bill, for-profit schools, such as those that have defrauded students nationwide and have been taken to court successfully, might well appear perfectly acceptable on the state's application form. They might well be approved by a well-meaning state board. They can, as many vendors do, send misleading advertising to parents to convince them to choose their inadequate programs, as has been done in the past. And districts would be forced to accept those credits toward graduation without Amendment 1348. Now, the Department of Education's approach is based on the concept of Darwinian selection. They believe that good programs will rise to the top and bad will drop out. I have to say there's no other nation in the developed world. I've studied international education and I've studied economics, and there's no other nation in the developed world that leaves their public education to choice. The education of our young people is the basis for the American dream. And the idea that each generation can exceed the accomplishments of their parents is what American opportunity is all about. So when we say choice, we have to give the students choices to move beyond what their parents can understand. By limiting a parent's options to those choices beyond their parents' understanding, we limit their dreams. I take myself as an example. My own father used to say, I have 4 children and I know what one of them does. He's a policeman. And the fact is that although my father was a very successful small businessman, he had no idea what an IT consultant, a robotics entrepreneur, or a healthcare marketing person did, or how they needed to educate themselves in order to go in those directions. And that's the American way. That is how education feeds the thriving American economy and helps people achieve their dreams. True choice is by providing quality options and guidance to children, not opening parents and children to scam artists or expecting parents who are juggling many jobs and responsibilities, all of those parents, to be able to review multitudes of options in depth and understand which is best for their child. Amendment 1348 does not limit choices, it curates them, letting the local districts who know the students, the families, and the businesses best to help guide them. I thank you very much for your attention.
Thank you, Senator Deitch. Any questions of the senator from committee members? Seeing none, thank you for your presentation. Griffin, have we got any people?
I have Donna Couture with her hand up.
I'm sorry?
Donna Couture with her hand up.
Donna Couture, yes. Ms. Couture.
Hi, could you hear me okay?
Yes, please,
Thank
your testimony, but we'll watch the 3 minutes here.
Yes, thank you very much for allowing me to speak today. I just wanted to first thank the senator for giving a really wonderful summary about the school's involvement in these extended learning opportunities and work-based learning experiences. That is absolutely where my testimony was leading in terms of the kind of support and guidance and safeguards we provide students who engage in these experiences. I will note that I do represent the Extended Learning Opportunity Network as a former president. And I want to reiterate something else the senator said, which was we now have regional structures in place throughout the state that support ELO coordinators and other educators within our districts to facilitate these experiences. We've gone so far as to create a high quality ELO framework that gives these an outline of these safeguards that must be in place, helps districts determine who needs to be at the table and as far as stakeholders, but also who needs to be responsible for issuing credit, how we do so, how we assess the student, and what have you. And so what's important to us is to make sure that those structures are in place. I will also like to say just quickly a correction from our standpoint to the commissioner's previous testimony around data. We in fact did speak with the commissioner about the data. However, we've heard many numbers come out from the state. Today, we heard 3% of our students in New Hampshire are engaging in extended learning. Yesterday, it was 2%. As a matter of fact, when we were meeting with him, we saw many errors in that data. And so we did not, in fact, validate that data, but we continue to hope to get more accurate data in the future. We do not think it reflects the vast amount of work-based learning and extended learning opportunities that are happening in the state. Regardless, we do want to see it move forward. We do want to see it continue to grow. We just feel it very imperative that the school remain the primary partner in these experiences and making sure that we do not encourage our students to bypass those safeguards and go directly to our employers. We feel our employers and the Department of Education do not have the capacity to support the students in the manner in which that they need. So moving forward, we will continue to support our districts in making sure that they have high quality ELO experiences, and we would hope that the department can engage us in that effort. As a matter of fact, having a database of approved vendors is very reasonable. As a matter of fact, the Department of Labor currently maintains an approved list of vendors across the state, and we utilize that.
Sure. I'm so sorry. You've reached the limit of your time.
Okay. Well, thank you again for allowing me to speak. I'm open to any questions if there are any.
Seeing none, thank you for your testimony. Okay, where are we at now? We about to close the hearing on Amendment 1348.
Let's see. I did have Shannon I did have Shannon Reed signed up to speak, but I no longer see her. And I did have Commissioner Elblue signed up to speak, but I think that's the last one, was just Commissioner Elblue.
I think we probably heard that testimony. Okay,
Hold on, let me bring him in.
we good? Close the hearing?
Oh, hold on. I just wanted to. Yeah, I'm assuming if I tried getting Commissioner Elbow back in because it showed he was signed up and willing to speak on the amendment, but I cannot find him on here. So I think we're all set now. Oh,
I see a name there.
Commissioner?
Hi there. No, this is Grant again. Sorry. It
sorry.
turns out I ended up speaking on the bill itself. And then, but the comments are really applicable to the amendment itself.
Thank you.
If there's nobody else raising their hand, I think that should conclude the testimony for the amendment.
Apologies. Okay, we're good then. Let's close the hearing then on Amendment 1348. And seeing no further business for the committee, I'd like to then ask if we go into executive session, would take a motion to do so.
So moved.
Then moved by Senator Ward, seconded by Senator Deitch,
Yes.
or vice versa. Heard you both. All right, there we go. We'll need to call the roll. So to move into executive session, Senator Ward,
Yes.
Senator Starr,
Wake him up.
Senator Starr?
I'm here.
we're going into executive session, yes?
Yes.
Thank you. Senator Morgan,
Yes.
Senator Deitch,
Yes.
Senator Khan votes yes. So we are now in executive session. I would like us to, we probably have, where do we want to start? We can start with at the beginning, 1384.
We have to start with 1558, make a motion on 1558.
Yes,
and then
thank you. That's
could
of
go
course,
to
of
the
course.
amendment.
That's what I meant. Thank you. So can we have a motion ought to pass on 15, just lost the numbers there, on 1558.
I move we pass 1558.
Are we talking about the first plain bill or talking about the amendment to 1558?
No, this is just the bill to get it on the floor. We can then consider the amendment and any changes to it.
Did we have a second for that?
Just get the bill on the floor. Second?
Yes, second.
Second by Senator Morgan. Okay, now let us consider Amendment 1384, but I would like to offer a replace all for 1384, which is numbered 1398. And we should all have that.
I don't. When would I have gotten that?
I sent it a couple times, Senator. I sent it yesterday, and I also sent it right before the hearing at noontime. It should be in the top of your inbox.
Okay, I'll be leaving this conversation for a bit then.
Not so top of, but at 12:01.
I was signing up at 12:01. So.
Yeah.
I can send it to you again if you'd like.
Well, let me,
It should say,
I'm not sure how to get out of the Zoom and to get into my regular account so I can get it. That's the whole problem.
if you, can you shrink the Zoom? like,
Yeah,
at the
I've
top?
shrunk.
Okay,
Okay, let me try this.
because we can.
And, well, and in presenting this, let me say, as I presented 1384, I indicated that there were two sections at the back that were redundant and not
Right.
needed on the brain injury. So Senator Ward, if you've taken notes on 1384, it's going to translate directly to 1398, and we'll be able to work with that.
Okay, you took 36 and 37 out, right?
That is correct.
Yeah, okay. If that's the only
Wait,
change.
and let me just check. 36 and 37 are up, yes.
Okay. Then I'm fine with it.
So let us review some of the testimony and see if there are any thoughts that people have about this. This bill begins with the inclusion of 13 to 21 inclusive. I would ask that we look at section 38. And I want to make sure that we have said that section 1 of this bill regarding that inclusiveness and Alan, would you please look at that and please make sure that what we have said in section 38 about section 1 taking effect July 1, 21 is in fact what we're doing here.
Sorry, can you repeat that? I was actually working on a Zoom webinar for tomorrow. What did you just say?
Look at section 1 of the amendment 1384 or 1398.
I do have an amendment to that first section.
Okay,
And it does,
but Alan, I wanted you to look at section 38 and make sure that number 1 there, section 1, is taking place in 2021.
it's actually section 36 in the
And it's section 36, of course, in
1398.
98. Okay.
Trying to find it.
I think it's taken care of it.
Yeah. I will send it to you, Alan.
Senator Ward, did you have questions about section 1?
No, I just have an amendment to section 1.
All right, let's hear it.
The amendment number is 1413S, and it's on page 3. It's section 2E, as in Eric. I want to add unlawful in front of the firearm.
Oh,
So let us make sure that we've got.
I think you're on the next bill, right? I have a question on the special ed age bill.
No, this is on this bill.
This is 1558, page 3, there's section.
I mean, the next section. Aren't we going to talk about raising the age of the special ed first?
No.
No, we're not there yet.
Okay.
You're,
Sorry.
but you're in section 2, right?
2, E.S. and Eric.
And
It says
then
possession of a firearm, and I want to add possession of an unlawful firearm.
Senators, it's line 37 on page 2 of 1398. Yes.
Well, we have different
Oh, yes.
numbers here. I have line 1 on 38 on page 3.
Okay, yes, because
I guess it depends on how the printer is printing it, right?
yes. Well, and this, yes, and this is your amendment, so it would be different, yeah.
Yeah.
But the line is on, if you're looking at Amendment 1398, and Alan is sharing on the screen too. Right there.
So would you just want to explain the intent there?
My intent? Well, I think it's a big difference from just possessing a firearm versus possessing an unlawful firearm, because if you have a license for a firearm, it's very different than if you just have running around with unlicensed, unregistered firearms. I just want to make sure that we're talking about an unlawful firearm. It's just a clarification of it.
Senator Deach.
I think this is very confusing because I think the intent here is possessing a firearm on school property, not possessing it. Well, how could they? I mean, they can't expel someone from school for possessing a firearm. That makes no sense.
But that comes further down. You're talking about if they have a firearm on school property.
Well,
right now you're talking about a repeated act under subparagraph, an act of physical sexual assault, act of violence, criminal threatening, and possessing. And I said an unlawful firearm.
I don't see how the school, I mean, if a student possesses an unlawful firearm, that's a criminal offense. How does possessing a firearm, unless it's on school property, how does that even enter into a discussion of expelling someone from school?
Well, I just think it still makes difference whether you have a license to carry the thing or not.
I'm saying
Excuse me. Wait.
It's on school property.
All right, we got to do one at a time because this is even worse in a Zoom than in person. All right, so Senator Ward, can you answer Senator Deach's question?
Yes, I think I have done that already, but I will say again that a couple of examples given here, and all I want to do is to say possessing a firearm is one thing, possessing an unlawful firearm is something different. And that's my whole amendment is just unlawful firearm.
Yeah. So what I want to, so we had testimony in two different ways. One that called our attention that if we do that simply here.
There are three spots where unlawful was changed or was added
In this amendment?
in Senator Ward's amendment.
Yeah, you know, the way it reads, the kid's in trouble, even if he's got a 22 at home. Possession, anywhere. No restrictions to like on school property.
So can I speak? May I speak?
Yes, you may.
So let's jump back up to, on my copy, it's line 27. And so I think this possessing a firearm or possessing an illegal firearm has to be read in context of any people may be expelled from school by the school board, etc., for an act that poses an ongoing threat to the safety of students. So it's only if you possess a firearm and you're threatening the safety of students, in which case it really doesn't matter whether the firearm is legal or illegal. It's the fact that you're threatening students with it that's the problem.
Yeah, but the law doesn't say that. It just says possession, period.
No, it does say that. See, that's E.
No, it does not in English, not printed in the paper.
Well, because there's a colon at the end of the constitutes on line 29, it has to be read with that sentence that goes before it. It's possessing a firearm is the end of that sentence in 2. That's in line 27, 28, and 29. In other words, what I just read. Possessing a firearm isn't a standalone phrase. It only makes sense at the end of the sentence above it.
The plain words are possession of a firearm, and that's what it says.
Yeah. So,
and that's what reasonable people think it means.
Well,
No,
lawyers are reasonable people, and lawyers are the ones who adjudicate these things.
So I think let us say, I know that we could debate this a long time. I understand what Senator Ward is trying to do. I think, Senator, this is a change from our current statute and from what's in here, right? I mean, this is.
Well, before that, we had talked about BB guns and paint, what is it, paint something, and a couple of other things, and that was changed in the amendment to firearm. So all I'm doing here is adding unlawful firearm, and that's my amendment. You can do whatever you want with it.
Yes. I think that we were addressed by somebody, and I'm confusing her name right now, who told us that one, this would conflict with ed rules, and 2, we would. So you've presented this amendment, right? We're now considering amendment
1413S.
Okay. And how do you?
So
I'm fine with us considering that at this point as an amendment to 1398. Are we ready? Is that has, you want to make that motion, Senator Ward?
I can make a motion that we add the word unlawful in front of the firearm on section 2E as in Eric.
Right. And Senator Starr, did there a second to this motion?
Yeah, I'd be happy to have a phrase saying, possession on school grounds.
No, that's not the amendment. Senator Ward, read your amendment, please.
I'd like to have in the section 2, E as in Eric, change possession of a firearm to possession of an unlawful firearm. That's my amendment.
Okay, is there a second for that amendment?
Yeah, I'll second it.
Thank you.
I have a question.
It's Senator Deitch.
So my question is, if we change it and a pupil brings a lawful firearm to school and threatens students with it, are you saying that he can't be expelled?
I don't think you should threaten anyone with a firearm, whether it's legal or not legal. This just makes a distinction that unlawful firearm is looked upon very differently than a lawful firearm. There are schools, I believe, or places where you can bring your legal firearm. And then there are places where you can't. And if you have a lawful firearm with you, it's very different than if you have a firearm that is not registered or unlawful.
That's all true.
Mm-hmm.
but it doesn't answer.
But
my
you still shouldn't threaten anyone with it, okay?
We,
So,
I think we understand that amendment. Is there more to your amendment than that, just that?
nope, that's
section?
it. That's it.
So if there's no further discussion,
There would, so before, you don't have to vote on that one because you will just vote to combine all three amendments together as a committee amendment.
oh, there are three amendments.
Yes, the one that was noticed, that we did the hearing on, your amendment, and then Senator Ward's changes right now.
I'm sorry.
That's okay. It's late.
No.
Trisha, are we on I'm sorry,
Yep.
Mr. Chairman, are we on 1384? I just don't want to forget to bring my committee amendment on.
Yes.
Are on 1384, but I have asked to introduce the amendment 1398, which deletes the two sections that were unnecessary.
Right.
So we are on 1398
Mhm.
and considering it. I had understood that Senator Ward was suggesting an amendment to 1398.
Which it would be, because 1398 is basically the new amendment, correct?
So what I'm wanting to do is go through the bill section by section
Mhm.
so that we can consider each amendment. Senator Ward wants to introduce an amendment to section 2.
Right.
That's been seconded.
Mhm.
I'd like to call for a vote on Senator Ward's amendment.
Okay.
Would we call a roll all in favor of those of Senator Ward's amendment to section 2, Roman 2, subsection E? Senator Ward,
Yes.
Senator Starr,
Yes.
Senator Deitch,
No.
Senator Morgan.
No.
Chair votes no. So we have defeated that amendment. And just to, do we have further amendments to we are moving forward. Further amendments. Section.
This is to 1558. I was just looking at Senator Morgan, sorry.
We're doing 1398, the
Mhm.
amendment 1398 to 1558. I'm wanting to just verify in my notes that the only thing I'm really concerned about is the implementation date of section 1. That's
So
my biggest concern. Anybody else?
So, Mr. Chairman,
Oh,
sorry, Senator Deitch, go ahead.
no, go ahead.
Mr. Chairman, it looks like I can add the language that we talked about for the federal funding piece that that Attorney Fenton brought to our attention.
You're wishing to turn to section 30?
Well, my question is, I can add it here, or I can add it in 1384. It appears. It appears as though I can add it in either amendment.
Yes, I think you can, and I'd like us to add it to 1398.
Okay. In that case, I propose a committee amendment to Amendment 1398S, section
30,
Roman 2, sub C, that will read, stand by one moment, please. It should start as saying applicable federal funding participation shall include, comma, but not be limited to, comma. And then it can continue, state set aside funds received from the federal government.
Is there a second to that amendment?
Second.
Thank you, Senator Ward. I think this is what Attorney Silverstein suggested to us, right?
Senator Khan, I'm very sorry to interrupt, but you can't vote on amending an amendment in committee. You need to just vote on a committee amendment that would include that language. There's no voting to amend an amendment in committee. You just need to have one committee amendment. So you can have a discussion, and when you're at what you think is an agreement that will be for the committee amendment, then at that point, you'll take a vote on a committee amendment.
So I will record all the changes that you all want. And if you all discuss that you want them, and then we can vote on it, the full committee amendment in the end.
Okay. Okay. Well, I accept that that is, we'll add that to our consideration of 1398. Again, I am asking Alan in section 38. We are clear in section 1 of this bill. Won't take effect until July 1 of 2021.
Yeah.
Are there any other changes that anyone wanted us to consider in 1398?
I can't find the section on the special ed. What page is the special ed age?
The special ed, what, Senator Deitch? I'm sorry.
Changing the special education age to be inclusive of 21.
It's on page 1, section 1.
It's the first one.
Oh, well, that's what I thought, but okay. Then somebody said we weren't considering it yet. Okay. So the issue that was brought up is germane in that, in essence, you're not fixing the problem if you just change it from 21 to 21 inclusive. You have the same problem the next year. As soon as someone turns 22, if it's in the middle of the year, the child has to leave school in the middle of the year. So the language, I mean, maybe we don't want to deal with it tonight, but this is not good. It doesn't solve the problem. It just adds another year. And the language should say something about toward the end of the school year, if a child turns 21 in the middle of a school year, services continue through the end of the school year, is what it should say.
Testimony presented was that the federal IDEA allows for through age 21. Senator Morgan, are you wishing to speak?
No. Woke up from nap. Just.
Yeah, well, to be real about it, if the kid graduates from high school at age 18, which is standard, and then signs up for a 4-year college, he'll be 22 before he graduates as a senior. Cut him off 21. That's junior year. He's got Gonna have to figure out how to pay for the senior year. We ought to go the whole route. Make it 22.
As the parent of a disabled child, I can assure you that we do not pay for college for disabled children, regardless how old they are. Okay, so if the problem we're trying to solve is just to make it match federal language, then perhaps this solves it. There was much discussion about the problem of people stopping in the middle of a school year and a child being disrupted because they get halfway through a school year and then are pulled out because they suddenly turn 21. But if the issue is just that we're trying to make the language the same as the federal one, then I guess we've accomplished that.
Okay. Everybody? So Jenny, you were keeping us on track here. We do have, and I'm sure Tricia is too.
Yes.
Thank you.
Trisha got you guys on track.
So we now it would be appropriate for us to take an action on the amendment to 1558.
If you have no other changes and you want those changes to be part of that committee amendment, yes.
Okay. So the change that we are making at this point is the one in section 30 recommended by Senator Morgan. And that is it. Very good.
Will you divide the question?
I'm sorry?
So will you divide the question? I will vote to approve the amendment to HB 1558 except for section 2. Everything else I'll vote yes on.
I don't believe we can do that, Senator, with an amendment in committee.
Okay.
Sorry.
So when do we do this? And the session on Tuesday?
Yes.
Okay.
Jenny shaking her head. Thank you, Jenny. Yes.
That's fine. That's fine.
Right now, we can just vote on this amendment with the changes, yes or no.
Okay.
And then we will vote ought to pass as amended on the bill.
Okay. It's too complicated.
I know. That's why we got all these staff members here.
That's a good thing.
We'll call for a vote on amendment 1398. Senator Ward.
No.
Senator Morgan.
Yes.
Senator Deitch. Senator Deitch.
Yes.
I'm sorry. Was that, I didn't hear that.
That was a yes.
Okay. Senator Starr?
No.
Senator Khan votes yes.
Okay.
So 1398 is adopted.
Mr. Chairman, it appears that we may be having an issue. Ms.
I'm so sorry. I'm not sure if I just missed it. Was there a motion and a second on the committee amendment?
Yes.
Okay.
Well, let's see. I believe
Yes. We had Senator Deitch.
Senator Deitch and Senator.
So that was the motion on the bill as ought to pass.
Yeah. Sorry.
I move the amendment.
And let's, so long as we're backing up, let's check something here. Senator Ward has an amendment that she wishes to offer that is independent of 1398, correct?
Yes.
And this is my confusion. I didn't see that, wasn't aware that that was, all right. So I think what I'd like us to do is to vote on 1398 as it is presented, and then allow for Senator Ward to introduce her amendment, which would obviously then be altering 1398. guess my point is, if 1398 is going to go forward, it would be good for us to see if we agree and then allow for Senator Ward's amendments to be introduced, which would obviously then change the overall bill. And maybe we would wind up a little bit further on consensus here. But so let us offer a motion on Amendment 1398.
Senator Deitch made the motion.
And a second.
I'll second it.
Okay.
So Senator Khan, just to be clear, this is just on 1398 without the changes that you had discussed as the committee amendment.
No, this is with the committee amendment, as with the committee amendment to
So you're
section 30.
So you're taking a vote on the committee amendments.
Jesus. So what are the committee amendments?
I move Amendment 1398 with the committee amendment.
Thank you.
Which is the changes that Senator Morgan asked for
Correct.
in section 30.
Correct.
And we already discussed Senator Ward's amendment, which it failed.
Right.
When you all took your poll.
Well, because we aren't allowed to amend an amendment. Therefore, we're just voting on 1398, and then we'll consider, so the action that we took on it before was not permissible.
That's
Right.
We're just going to vote on 1398, and then we'll separately consider Senator Ward's amendment and talk about that.
But this,
What about Senator Khan's amendment to scrap
no,
36 and 37?
Now that's part of 1398.
It is.
Yes.
yes.
So I think it's important that moving forward, if you're talking about the 1398 with the changes, to refer to it exclusively as the committee amendment. It's because it's creating a lot of confusion.
Well, because we can't have more than one committee amendment. So Senator Ward's changes either have to go into this committee amendment or they're not considered at all.
Okay. You do it the way it is supposed to be done.
We can't have two amendments on HB 1558. They all have to be rolled into one committee amendment.
Okay.
All right. But Senator Ward, would you consider, or would anyone consider if we just struck the firearm bullet altogether? Because when I read this, it says if you're threatening somebody, it doesn't make any difference whether you're threatening them with a firearm or a knife or this or that. It's if you're threatening them, you're threatening them, and that is qualified under this. So what if we just struck the firearm?
That's fine with me. I'll accept that.
I think
D says criminal threatening.
I think we are moving in a direction that we are not prepared to deal with the consequences of. And I think that there are two things that were presented to us. One is that we have the federal requirements of no possession of firearms in a school, and that it affects future federal funding to do this. So I think that it is correct that it's here. I think it's been a part of statute for a long time. And that this is not a change in the current suspension and expulsion wording. This is just carrying forward what's already in education rules and which is adopted by the state for the purposes of accepting federal funds.
I have a question.
Senator Deitch.
So are you saying that if we adopted Senator Ward's amendment, we would lose federal funding?
I heard that in the testimony. Am I incorrect? We probably, oh well. We probably have somebody who provided that testimony actually listening to us. Is that
We have a hand raised.
Oh, Michelle Winger, and yeah, is the person that provided that. Ms. Wingeren, can we recognize her?
Thank you, Mr. Chairman. I wasn't sure if I should pipe in on this or not. I will say that it would, if the committee chooses to remove the firearm provision from section 2E of the bill, of section 2 of the bill, or of the amendment, I think that that's fine. There's a separate section 4, Roman 4, which is the language that tracks federal law. So removal of possessing a firearm in section 2 would not jeopardize federal funding, if that's the committee's desire.
And how does it go against existing Department of Education rules? And that was yes, right?
No, the rules have to follow the statute as opposed to the statute following the rules.
Yeah.
So that would not make a difference either. And I think that Senator Deitch is probably correct that for purposes of section 2 of the amendment, criminal threatening would get you to the same place. There would be the separate expulsion provision under section 4, Roman 4, that would track federal law and keep New Hampshire, retain New Hampshire's ability to accept federal funding.
I think maybe we need to refocus to where we were in the process before we got sidetracked with what could happen if we removed the firearms piece from that section. Go back to what we were actually doing as far as voting on the amendment, what that amendment was, what the committee amendment was. And I think that Tricia has that ready, but we kind of just went on a tangent and I think we're getting lost in it. So let's try, we can refocus. We can do this.
So the proper step here is to say that I don't agree with that amendment, or what?
Right, and just, yes. Well, you all voted among yourselves that you don't want that in the amendment, in the committee amendment. So now you will just move forward. Sorry, Senator Ward. You will just move forward with the changes that you agreed upon with Senator Morgan, and now you will vote on that on 1398 with Senator Morgan's change. That's it.
Correct.
All right,
So-
we have
so-
a motion. The motion was made on
And-
1398.
Can I withdraw my motion?
Sure.
You can.
Okay, well, I withdraw my motion in order to suggest additional changes in the committee amendment.
Okay.
And that is the second withdraw.
Senator Ward withdraw her second.
Senator Ward, you withdraw your second?
Yes.
Okay.
Okay, so I suggest that we make an additional change to the committee amendment and remove the bullet point, which someone else probably, okay. E. We remove bullet point E under section 2.
Okay.
And I move the amendment with the committee amendment.
Okay. With those changes, you want to move it?
Yes.
Okay. Is there a second with that change?
Second.
Okay.
Okay. Now let us vote on, we've got a motion.
Yes.
Second.
Mhm.
I'd like to, if we can close discussion, I'd like to vote. On the amendment, and Senator Morgan, Your question,
I don't think that there's a need to make this additional change, to be clear. I think that the change that we made in section 30, there's a very clear reason for it. And the change that we're making right now seems to be somewhat off the cuff and unnecessary. And I don't feel like I'm doing my job if I don't state that.
I agree with you. I think that this has been a part of statute for a long time, and I don't know why we would be deleting it.
If it's okay that if it's necessary to revisit, then we can revisit it in a future legislative session, but I don't think that this is the appropriate time for this change.
If we go forward with a unanimous vote versus a partisan vote, is that reason enough?
No.
Okay, so you stand on your principles and I will stand on mine. That's how easy it is.
We've heard from testimony that it makes no difference substantively, so. why
Yeah,
not?
and that is the other side to this, is that if we listen to and look at section 4, it's still there. Any student who brings a firearm in without written permission I'm still against it, I guess. Okay.
So do you want to vote on that with that change? And then any ultimate?
Well, I'm a little flummoxed here, Alan. If some of us don't agree with that section being removed, do we? What do we do?
Well, that wasn't an amendment. That was just a suggestion from Senator Deitch. So we don't have to do anything except if we do want it to be in the committee amendment. Jen.
Yeah, you have to vote on it.
They made a motion in a second.
Okay.
They have to.
Yeah, I'm just going to say I've really got to go to make a family birthday party. So good luck. Goodbye.
Hi, David.
Okay.
All right, so we do need to vote on it. Sorry.
Now
it doesn't matter as far as they can divide the question on the floor if it's something that they feel that strongly about, and we can deal with it then.
I think that's a good way to go. Divide it on the floor and we'll debate it.
So we just need a roll call.
So are we voting on when we do this? Are we voting on the change with just section 30 or with both simultaneously?
With what Senator Deitch wants as well. And if it fails, then you can go back and you'll have to vote on the committee amendment with just your change. But if it passes, then, I mean, there's 4 of you now, so it could, I don't know what happens in a tie, Alan?
Well, I do. It fails.
Okay.
But let's not that I'd say here. I'm going to change up the idea here. Alan, we had amendment 1384 in our packet. It is we could act on 1384 as it's presented. We could then propose committee amendments, right?
We would still need to vote on what Senator Deitch had put forward because there was a motion and it was seconded.
Mm-hmm.
but I understand, but we could withdraw that. My point is 1384 is another basis. I don't care at this point. I guess what I'm saying is that each committee amendment could be considered separately.
Well, we would have one committee amendment.
Yeah,
There wouldn't be more than one coming out here.
you can't, yeah.
If we approve 1384,
Mhm.
then I hear from Senator Morgan that he has an amendment to 1384 that he'd like to make. Then I hear from Senator Ward that there is an amendment she would like to make. And then there's an amendment I would like to make, which deletes those two sections from 13 that are duplicated.
You would
Is
have
that
to,
another way we can go? So that we get a positive approval, a positive motion on 1384, given that we will consider each of the committee amendments that is proposed?
no, because you still only, once you vote on a committee amendment, then you need to vote on the bill ought to pass with the amendment. There's no more voting on amendments after that to go on the bill. You could do a floor amendment. You could do floor amendments.
Would you say this is part of the problem when you have an omnibus bill? Because you have so many different things included in it.
No, I think this would have been yeah, maybe so, Senator. But we are where we are, and I think we've got good legislation here on which there's a single point where we disagree. And that's why I'd like to separate these, and I'm trying to see if 1384, because it's a given, could be voted on. We could then add these separate committee amendments so that we come out with a single 1558 with amendment.
Right, that's what would be wonderful, but you can't vote on 1384 as the committee amendment and then consider any other amendments. You have to vote on one amendment as a package.
So I think what we need to do is we need to either decide that we're going to take up the vote for Senator Deitch's motion and that was seconded, or she can withdraw it. And then we can move forward with that, because honestly, we were in a place where we could continue to move forward on it before we got sidetracked with that. So if we deal with that, then we would go back to what we were dealing with as far as that amendment, which was 1384. Is that the right number?
1398.
98, Senator Morgan. Right. Okay. So
Senator Morgan's change.
So why don't we do that first? Let's deal with the motion that Senator Deitch had made to strike that one line, and then go from there, because we're just going down a rabbit hole here.
Yes, we are. Your
So-
suggestion here is 1398 with the 3 committee suggestions,
With the 2 committee suggestions.
2 committee suggestions.
Mhm.
Okay.
So you have to do a roll call.
Senator Ward.
What are your committee suggestions? We have gone round and round, so I
Yes,
don't know at
so
this point.
we have Senator Morgan's suggestion in section 30, the change.
Yeah.
Okay, and then we have Senator Deitch's suggestion that we remove the letter E, the firearm.
Right. And what about Senator Khan's scratching out 36 and 37?
That's in 1398.
It's in
Okay.
998.
That'll
Okay.
be already, it's already done.
Okay.
All right. Call the roll.
Mhm.
Senator Ward,
Yes.
Senator Deitch,
Yes.
Senator Morgan,
No.
Chair will vote yes.
Okay. So 3-1, you have a committee amendment.
So I move
It's
the
already moved.
bill.
Yep, it's already moved, ought to pass as amended. We
Okay.
just need a roll call.
Senator Ward,
Yes.
Senator Deitch,
Yes.
Senator Morgan,
Yes.
Senator Khan votes yes.
Okay. All right.
Okay. Let's go to 1582.
Mayor Khan, sorry, who's taking that one out?
Oh, yes, sorry.
I will take it out.
Okay. He's keeping us on track.
1582. Can I have a motion ought to pass?
So moved.
And second? Senator Morgan?
Yes, second.
Okay. We are now to consider Amendment 1327.
Yes.
Do you need a motion?
Well, we need a motion, but I think we are back in this dilemma of, are there committee amendments here? And
Need a motion to discuss it?
so I think we need to do that. So are there any suggested committee amendments to to 1327?
Senator Morgan, did you want to move 1327?
Yes, please.
I'll second it.
Thank you.
Thank you, Senator Ward.
I would like to ask in this, are we going to, there was a suggestion by the university system about sections 22 and 23 being deleted. I think we took that vote in the Senate earlier. Is there a strong preference from Senator Morgan on this?
I would not say that. No, I'm not going to offer a change at this time. Sure.
And I would like to ask if we would change the implementation of sections 1 and 2 to so that we take section 24 on the effective dates, and that we add to section 2 sections 1 and 2, comma, 16 through 21. The net effect of that is that relative to disabled veterans, children, that that tuition waiver would be effective only after that section took effect, which would be July 1, 21.
And Senator Khan, can you, for me again, which section is that we're changing? the date?
Section 24 and number 2, Roman 2.
Hold on.
Sorry, just
Yep.
to clarify something right now of where you are in process. Where you are in process right now is Senator Morgan moved and seconded by Senator Ward, the amendment 1327 as is. You have not, so if you're looking to change that amendment, you need to withdraw those motions and make a motion for a committee amendment that would include those changes.
That is what I would request.
Okay. Senator Morgan and Ward, will you withdraw your motions?
Yes.
Yes.
Thank you. Would you accept that
Okay.
change? Senator Morgan?
Yes, I'm sorry. Yes, I was muted.
I'm sorry, is there a page on that? I can't find the section you're talking about.
I'm in the calendar.
Oh.
So Tricia, it looks like he's changing on the amendment itself.
Yeah.
1327S.
Right.
Page 10.
Thank you.
Line 30. He's looking to put in sections 1 to 2, comma, 16 to 21 of this act shall take effect July 1, 2021.
Okay, so 1 and 2 to that number 2 there. Okay.
Exactly. So on page 10, line 30, that's my understanding.
Yes.
I'll wait for Senator Khan to correct me if I'm wrong.
No, I think you're right. Sections 1 and 2, 16 through 21 of this act shall take effect July 1st, 2021.
That's my understanding.
Yes.
I have
You're right.
the Colonel Perry had requested 16 through 19 be effective as ASAP.
Yes, he did.
Yes, that was so that the National Guard, right? Is that the National Guard section?
16 to 19.
Yes,
Because
it is.
that affects their recruiting.
Yeah, that's right, for the recruiting.
Mhm.
And if you have including the 21 to July of 21, that's going to take them another year.
So we could just put in sections 1 and 2 of this act shall take effect July 1st, 2021, and then those sections that he wants will just be in the remainder of this act shall take effect 60 days after its passage.
Okay. Because those were the ones 16 through 19 were his requests.
Right. Unless you want to separate 20 and 21.
I don't care.
Uh,
All right, so.
we. I know which sections these are. I know the intent of doing so. I just am, that would require a section 4. Is that not right?
No. You could just remove,
Because I'm having trouble finding this. This is,
I think, do you have the amendment? Well,
yes, now I have it.
okay.
1582.
Mm-hmm.
And we're going to do what?
So on down by the effective date, you're going to have in number 2 there, it's going to say sections 1 and 2 of this act shall take effect July 1st, 2021, which is what you suggested. And then section 3 still says the remainder of this act shall take effect 60 days after passage. So those sections that he wanted will be included in that line.
Except 16, right?
That's okay with me. You know what I worry about? Should that say upon passage? Should there be a section 4 that says that 16 through 19 should be upon passage?
Oh, okay.
Because it gets very confusing if he said ASAP, right?
Yeah.
ASAP isn't 60 days later.
I think I would agree with Senator Khan. I think there would be a new paragraph 4, or I'm sorry, a new section 4, or yes, a new paragraph 4 under section 24 that specifically says section 16 to 19 will take effect upon passage. Is that correct?
Yes.
Okay. So I think that's the process. Tricia, do you understand that? Because
Yep.
Mary Ellen is also on this call, I believe, and if there's any guidance she might be able to offer as she drafts this.
Well, yeah, that takes care of those sections. So 20 and 21 will still be in the section, Senator Khan, that takes effect July 1st, 2021?
Yes.
If you want, okay. So the number 2, Roman 2 will say sections 1 and 2, 20 and 21 of this act shall take effect July 1st, 2021. And then probably that she will put this next section as section 3. Section 16 to 19 will take effect
On passage.
on passage. And then the remainder of this act shall take effect 60 days after passage.
Mhm.
All right, we have a motion. That's moved and seconded.
Motion. Nope.
I think not yet. I know. We don't yet, but let's take one.
I move.
I second.
We're moving,
Okay, Jenny, is that, okay, great.
moving amendment 1327 with
With the changes.
changes just discussed.
Mhm.
Let's take a vote. Senator Ward,
Yes.
Senator Deitch,
Yes.
Senator Morgan,
Yes.
Senator Khan votes yes.
Okay. Now we have ought to pass as amended.
So moved.
Second.
Senator Ward,
Yes.
Senator Deitch,
Yes.
Senator Morgan,
Yes.
Senator Khan votes yes.
And who's going to take that out?
Senator Morgan,
Morgan.
Yes, please. Thank you.
And thank you, Senator Morgan, for fighting for this one.
and now let us do House Bill 1454. We have an amendment that let us discuss. Amendment 1348. Senator Deitch.
You want to move the bill?
I would move
Don't
House
we need
Bill
to prove it with the
1454.
credit amendment?
All right, Senator Deitch has done that. I'll second. Senator Deitch.
I'm sorry, I had a question. Are we moving it with the committee amendment?
On 1454. We have committee amendment. We're now going to discuss. We have just put the House bill on the table. We are discussing Amendment 1348. And we need to hear, are there any committee amendments to 1348?
Yes.
Yes. And I think we know what that is. You've already suggested that. That is to adopt rules pursuant to RSA 541A, comma, add the word that. Is that the correct
Yes.
change?
Adopt rules pursuant to RSA. Okay, add that back in.
With the addition of the word that.
And where is that word going, Senator Deitch?
It goes right after RSA 541A.
Okay, and then that.
That establish a process.
Okay, because that rest is still crossed out. Okay. Okay.
All right. Seeing no other questions, I'd like to have a motion to a vote on Amendment 1348 with the committee amendment.
I so move.
Second by Senator Morgan. And ready to vote? Senator Ward,
No.
Senator Deitch,
Yes.
Senator Morgan,
Yes.
Senator Khan votes yes.
Okay, now the ought to pass as amended on the bill.
Motion ought to pass.
We don't
As
need,
amended.
you've made the motions. You can
It
just,
does exist. Yes, it already made. All right, let's vote on the motion as amended. Senator Ward,
No.
Senator Deitch,
Yes.
Senator Morgan,
Yes.
and Senator Khan votes yes.
Okay, and who's taking that one?
Senator Deech.
Each.
Okay.
All right, seeing no other business before us,
Are you sure?
I think so. I gotta say, it is tough to have changed the committee amendment. That got confusing.
I'm sorry, I should have been more bold.
Yeah, well, maybe we just should have done that without having a new amendment that people didn't all have in front of them. That being said, I think we can have a motion to leave executive session,
So moved.
So moved.
and seconded. Take your pick between Deech and Morgan. They're both on it.
Yep.
Vote to end it, to come out of executive session. Senator Ward.
So moved.
No, it's a yes.
Oh, yes.
Senator Deech,
Yes.
Senator Morgan,
Yes.
Senator Khan, yes. So we are now ready to accept a motion to adjourn.
So moved.
Second.
And that's on the floor. Hold it a second. I want to just say to Tricia, to Jenny, to Griffin, to Alan, to Deb Maratone, thank you for helping us get through
We really appreciate
Education
it.
Workforce Development Committee's first Zoom meeting.
Thank you all very much.
Thank you guys.
Good job. Very good.
Our
job.
pleasure.
We're voting to adjourn. Senator Ward,
Yes.
Senator Deech,
Yes.
Senator Morgan,
Yes.
Senator Khan votes yes. Thank you all very much.
Bye-bye.
Thank you for pulling